Lots.
Okay.
Much. I have a prayer for listing of an FAO on Wednesday. Already, the Honorable Court has granted stay order, and the execution lower court has fixed the case on 4th of September and directed the judgment debtor to furnish the up-to-date order of the Honorable Court. Otherwise, they will proceed with the execution matter. On Wednesday, on 3rd, kindly take up.
On Wednesday.
On Wednesday.
It's pending at which date?
Notice was issued by the Honorable Court. Stay was granted. Notice was issued. Thereafter, it did not.
On Wednesday.
On Wednesday. Lordship.
Lordship, I would like to mention these items because these were filed in May itself, Lordship. They are not yet listed, and in the meantime, execution proceeding has started. Lordship, can it come on Wednesday, Lordship?
Fine, on Thursday. On Thursday.
Thursday is a hearing day, Lordship. So
It's okay.
Thursday.
We'll try to accommodate.
Fine,
this.
highly obliged.
We have to leave, Lordship.
One MSc appeal was dismissed on default in the year 2023. A restoration petition is filed and notice was issued in the year 2023 itself. But thereafter matter has
When
been
which date?
Wednesday loss.
Huh?
Wednesday or Thursday.
5th September.
Yes.
But I have a similar prayer for listing of an IF for me. It was last listed on 23.
It is 8 September.
No, 8, not on 8. 9th. All right.
May please,
Yes, yes.
may please, Lordship. I am making prayer for listing of an MSc appeal, my lord, under orders column, my lord. It is basically for the release of 50%, my lord, that generally. And the
Date
Any
of the
date?
DDA. 8 September.
oblige.
May I please, your lordship. Lordship, I beg to mention item number 39, lordship.
Hmm.
As per office note dated 28/8/2025, service report is awaited, lordship. So the matter may be concluded for the day.
Service report.
Service report is awaited.
Waited. You are seeking adjournment.
Yes, lord.
Which one?
39, lordship, in orders call.
Learned Counsel, Mr.
You Ghosh, lordship.
On behalf of?
My name is in the cost list, lordship.
No. Oh, yes, it is there. Okay. Has prayed for adjournment, list the matter on after 2 weeks.
Much
Service
obliged,
report on respondent who?
lord. Sole respondent, lordship.
Or service report on respondent is awaited.
May I plead your
Plead your
lordship? Lordship, I beg to mention item number 3, my lord. Matter may be listed after 2 weeks, my lord.
Have you taken,
Motion matters, my lord.
Okay. Learned Counsel, Miss
L. Wajida.
L. Wazida has prayed for adjournment, list the matter after 3 weeks.
2 weeks.
2 weeks.
Obliged.
Please, your lordship. Lordship, I beg to mention in-test case for listing. In-test case for listing. Any date as per your convenience.
No, I'm not. I think you have to secure. We'll have, no, this roster is not before me. You'll have to mention before another bench.
Obliged.
May I please, your lordship? Lordship, I beg to mention for listing certain IAs arising out of arbitration appeals, lordship. Lordship, the urgency is that execution proceedings have started, lordship. So there's a certain urgency.
8 September.
Much
Please,
obliged.
your Lordship. I beg to mention an RSA, Lordship. The matter may be listed in the orders column, Lordship.
RSA. 10 September.
May I please, Lordship. I pray for listing of a civil revision for an order column, lordship. Any date?
Dated on reason.
Oblige.
May I please, your lordship, I'm seeking for an update for item 45 of today's daily, lordship.
Upgrading.
Lordship,
Item number.
45, lordship. Lordship, the matter has been left
What time?
part heard. The matter has been listed part
Okay.
heard, lordship, for hearing.
Or 2 PM could you apply? At 2 PM, yes.
I have the observation.
May I please, your lordship? Lordship, I would like to mention one MFA under orders column.
Dated on reason.
Obliged.
May I please, your Lordship? The Lordship, I pray for listing of an interlocutory application for condonation of delay, your Lordship. The matter was last listed on 26th of June.
Delay of what matter?
Delay with respect to the filing of the miscellaneous first appeal, your Lordship.
Dated on reason.
11th September. Much obliged, your Lordship.
May I please, your lordship? My lord, item number 32, actually the matter has been compromised. So I have been asked to withdraw that, yes, my lord.
Okay.
Item number
Yes, ma'am.
32,
Go to the-
yes. Item number 285 of 2020.
CRP.
My lord, CRPIO, yes, ma'am.
Learned Counsel, Mr. A. Sakkar has prayed for withdrawal of this petition as the matter has been amicably settled between both the parties. Okay?
Yes, ma'am.
Okay. So this is
Accordingly, when this will be withdrawn, my lord, the respective,
to the
yes, that
trial
will
court.
also be withdrawn, yes, ma'am.
Petition is dismissed or disposed of?
No, disposed of on withdrawal, my lord.
Petition is disposed of on withdrawal.
And my lord, the LCR which has come, TCR, is
Trial court records.
TCR
no,
is same?
only the scan copies.
Okay, then it's all right.
Scan copy just no, it was more cipher. I'll check. I didn't only the scan copies.
If it is a scanned copy, need not to be sent back, but if it is a scanned copy, then need not to be sent back. Oblige, your lordship.
এরকম original আছে,
Wait, please, Your Lordship.
থাকলে ভালো।
Wait, please, Your Lordship.
Hmm.
Lordship, sir, back to mention for listing of an RFA, my lord.
RFA
For order, my lord. Next week.
for orders column of RFA data details.
May I please, Your Lordship, I beg to mention item number 13, Lordship. Lordship, kindly matter may be taken up after vacation, Lordship.
After vacation.
Yes, Lordship.
Have you taken consent from the other
Yes,
side?
yes, Lordship.
Learned counsel, Mr.
A. Hussain.
A. Hussain, with the consent of the other side, has prayed for adjournment, leave the matter after Puja vacation.
May I please, Your
Puja
Lordship?
vacation 2025 date, okay.
May I please, Your Lordship?
Hmm.
Lordship, I am praying for listing of an RSA which was last listed on 31st July of 2024.
This can be listed, data on the 11th September.
Obliged.
May I please, Your Lordship, I beg to mention listing of 2 CRP civil revision petition for admission on this coming Friday.
For admission.
Yes, yes, yes.
So. 8 September.
Right.
For one second appeal, my lord, pending, my lord, second appeal. It was last listed, my lord, 24/1/25, my lord.
At what stage?
My lord, for orders, this, my lord, order.
Actually, I beg to mention an RSA matter which was listed last on 2019 for hearing. It was never listed back again.
May it please, Your Lordship. Lordship, I beg to mention for one regular secondary for orders on 15th of September, Lordship. Amicable settlement is going on between the parties, so matter is in mediation, it will be resolved on that, so for that, Lordship.
So
If
on
possible,
15th September.
if possible on 8 or else on 15th.
Consider by 8 September.
May I
Obliged.
please, Your Lordship? Lordship, I beg to mention on CRP IO, Lordship. Lordship, the matter may be taken before 8th of September, Lordship. The trial case is on 8th of September.
5th September.
5th September.
May I please, Your Lordship. Lordship, this matter may be released on my Friday, Lordship. Matter is relates to Lordship one matrimonial dispute. Lordship, lawyer court directed the appellant to deposit to pay rupees 10,000 per month, Lordship, 1 year back. But till date, he has not deposited on.
Friday, we,
That was last listed on 6/11/2024, Lordship.
on Friday,
Yes, Friday,
5th September.
5th September.
I don't know the one. It will go on.
May I please, Your Lordship, I am appearing on behalf of my senior, Dr. P.M. Kokoi, who is presently engaged in another court. I kindly seek first over for time being.
My lordship, in this petition, the respondent husband has filed a divorce petition in Udalguri, whereas the petitioner, she resides in Borpeta with her parents. Both the parties have been living separately from June 2022. And from last 3 years, she is a housewife. She doesn't have any income and she's dependent on her aged father who runs a small grocery shop in Borpeta. And moreover, there are already 2 cases which are filed by the petitioner in Borpeta, one before the learned CGM court and one before the learned family court. So if the divorce petition is transferred to Borpeta in the interest of justice.
From Guwahati?
No, from Udalguri.
From Udalguri to Borpeta.
Yes, my lordship.
Let us issue notice first.
Yes, sure, my lordship.
Learned counsel Miss
Anindita Deka.
A. Deka is present on behalf of learned counsel Mr.
My lordship, I am the learned counsel for this. I have filed my
Item number
Two, my name is not listed in the, this.
But you have
Yes,
submitted.
yes, sir, yeah,
wakalatnama.
wakalatnama.
On behalf Nalai is present for the petitioner, post of petitioner to take steps to issue notice to the respondents. One respondent or how many respondents?
One, only the
To the
husband.
respondent returnable within 4 weeks. Issue
Apply.
list accordingly.
IO against the interlocutory order under Article 327 and 151, 1 and 5. Before your lordships.
Will issue notice?
My,
Will issue notice? Or you want to submit something?
I wanted to submit something
Okay, yes.
on to that maybe record may be called for, my lord. A record may be called for, and also stay the further proceeding.
Let's see. Yes.
The impugn order against my lord, that is at page 82. The facts of this case is there are in
Page 52.
82.
82. What is the order?
Order that is, we have filed an two applications. One applications, my lord, under under order 6, rule 17 and 151, as well as that is the 481, and also one applications under section 144 and 145 of the Evidence Act for amendment of plaint as well as to re-examination of the PW1. What happened in this case, my lord, the plaintiff has filed a suit against the defendant for some contractual agreement, against the contractual agreement. They have not filed any document with the plaintiff. And as per where we can know about the suit that we appeared here, then they have also supplied to us this plaint, copy of the plaint. Then no documents has been annexed in there. Then in accordance with the plaint, we have filed a written statement. With the written statement as well as the plaint of the plaintiffs, issues are filed. Then when the evidence has been submitted, then some documents has been exhibited. And those documents are not supplied at the time of the hearing. Then we have the line of trial court compelled to us to cross-examine the PW1, that is the plaintiff. Then we have cross-examined. Then we submitted before the line of trial court that we have not received any copy of the documents, which they have been filed as an exhibit 1 to 10. Then we have filed an application before the honorable court for amendment of the written statement, as well as to re-cross examination of to the PW1, who is the plaintiff. They have filed a suit against their agreement, in which agreement is a fake agreement. That agreement is also not filed at the time of the file of the plaintiff. In the meantime, the line of trial court framed issues on the basis of the pleadings of the parties. That issue has been not framed by the line of trial, that whether the agreement is a fake or not.
Please read the impugned order.
Both sides are represented. Today is fixed for passing order on petition number 481/25 filed by the defendant under order 6, rule 17, read with section 151 and 151 of CPC with a prayer to allow the defendant either to file additional written statement or to amend the written statement. Petitioner's case in brief that the plaintiff has filed the suit without any documents, and as such, the defendant had to prepare his written statement based on the affirmations made in the plaint. That later on, plaintiff has exhibited 10 numbers of documents in his evidence on affidavit. It is submitted that the exhibited documents are not sustainable under law. Being manufactured documents, it is further submitted that as the plaintiff has not annexed the documents along with this plaint, consequently did not supply to the defendant, for which the written statement was prepared and filed by him without getting the opportunity to go through the documents. In view of the above, it is submitted that the written statement requires amendment or additional written statement may be allowed to be filed by the defendant. Plaintiff has filed a written objection, denying and challenging inter alia the claim of the petitioner defendant, and further stated that prior to the written statement or to amend the written statement, after completion of cross-examinations of plaintiff is not permissible under the provisions of law. That section 153 empowers court to amend and defect or error in a proceeding of a suit. That in the present case, the defendant could not make out the case for any defect or error in the proceeding. Moreover, amendment could not be allowed after commencement of trial, since the trial has already been commenced and the plaintiff was already cross-examined by the defendant. Hence, at this belated stage, if the prior is allowed, then it will cause prejudice to the plaintiff and also cause delay in disposal of the suit. I have already heard learned counsels of both the parties. Peruse the materials are available in the case record. Record reveals that the suit is filed for specific performance of agreement for sale dated 19/8/2013. Careful perusal of record reveals that defendant had appeared personally on 16/3/2024 without proper service of summons, and accordingly received copy of the plaint as per direction of the court. Record further reveals that on the date of the presentation of the plaint on 29/2023, plaintiff had filed copies or relied upon documents with a list which is found very much available with the record. Now, if the defendant was not provided with the copies, then she could have raised it at the stage of receiving the copy of the plaint. Moreover, defendant had also the opportunity to raise the same at the stage of discovery and inspection. Record reveals that defendant remained silent till the cross-examinations of plaintiff is over. Thereafter, has turned up with the plea of violation of the provisions of Order 7 Rule 9 and Rule 14 of CPC. Therefore, under the present facts and situations, the plea of defendant regarding the non-annexation of documents by the plaintiff with the plaint is not convincing in the light of the fact that the written statement has been filed long back on 16/5/2024, and the cross-examinations of the plaintiff is already completed. Moreover, defendant had knowledge of the pleadings and had the opportunity to seek inspection or to file additional pleadings or at appropriate stage. That besides, since the defendant has not raised any objection at appropriate stage, hence it can be presumed under section 119E of the Bharatiya Sakya Adhinayam that provisions of Order 7 Rule 9, which provides the preconditions for admission of plaint, and Order 7 Rules 14.
Have you annexed the petition?
My,
Your petition under order 7 rule under order 7.
yes, my lord, that
Have
is,
you annexed the petition?
yes, my lord,
Petition?
yes, petition is there also.
Which one?
At present, my lord. That is, my lord, at page 79.
Page 79.
That is 75, your honor. 175 and 179.
Two petitions.
Two petitions. We have filed. That is 75, your honor, my lord. Application under order 17, rule 17. And section 142, 143 of the BSA. Section 137, 131 Indian Evidence Act old, which read with section 151 of the Code of Civil Procedure. And
But you see that trial court has held that plaintiff has submitted documents.
they have been submitted the documents with the, not with the plaintiff. We have been submitted the plaint before the Lordship.
No, but a trial court has held that plaintiff has furnished the copies of the documents.
Copies of the
Did not believe your submission that you have not received copies of the documents.
Yes, your honor, my lord, come to the copy of the plate. We have been you have been annexed there with your copy of the plate. That is the page 16. Page 16. That is my yeah.
Okay. All right.
My lord.
All right. Stay till the next day.
Yes, my lord.
Our learned counsel, Mr.
B.N. Sharma.
B.N. Sharma, for the petitioner, Srimati Bandi Talukdar.
Balika Talukdar.
Balika Talukdar, who has filed his application under Article 227 of the Constitution of India, read with Section 115 of the Code of Civil Procedure 1908, full stop. The petitioner is aggrieved by the order dated 28/7/2025, passed in connection with TS number 12/2023 by the learned Civil Judge Senior Division Baksa Musalpur, rejecting the petition number 481/2025 under Order 6, Rule 17, read with Section 151, 153 of the CPC, with prayer for filing an additional or amendment written statement by the defendant, and also rejecting the petition number 482/2025 under order 18, rule 17 of the CPC, read with section 142 and 143 of the BSA 2023 and read with section 151 of the CPC. First up, it is submitted that the plaintiff has brought up a suit against the defendant, i.e. the present petitioner, on the basis of a fake agreement, full stop, while sending a copy of the plaint to the defendant, the plaintiff did not annex relevant documents, including the allegedly fake agreement relied upon by the plaintiff. Full stop. However, to the utter dismay of the defendant, the plaintiff, during the stage of evidence, introduced some documents and also issues were earlier framed based on the documents introduced by the plaintiff at the stage of evidence. Full stop. The plaint, the copy of the plaint marked as document 1
Yes, my lord.
at page 16 of the petition clearly reveals that no annexures were appended along with the plaint. The defendant is highly aggrieved as the defendant was unable to submit his written statement in the documents relied upon by the plaintiff, and he is thus prejudiced. First of it appears that an order of stay may be passed against the impugned judgment and order. Call for the scanned copies of the trial court records. Meanwhile, the order impugned by the petitioner dated. What is the date of the order?
Which, my lord? 28, that is, order that is
28/7/2025.
28/7/25.
The next date of listing. Issue notice to the respondents returnable, respondent, notice to the respondent returnable within 4 weeks, list accordingly.
Record may be called for, my lord.
I have called. Scan copies of the record.
Yes.
Item 1. Item 1.
I beg to apologize, Your Lordship. I was in the other place. Here in this case, this is the third time, Your Lordship. I've been filed before this honorable court. And the section which have been attracted is under section 302 IPC.
Then we'll have to call for the CD or trial court records. Sashid has been submitted.
No.
Not
yet,
submitted.
Not been yet submitted.
Okay, call for the CD, list the matter on. Koon Thana, which place, which police
Is
station?
it from Gwalpara perhaps?
On Pisole.
Gwalpara.
17 September.
Deeply.
May I please, Your Lordship? CRP IO, Your Lordship. Violation of against the order dated.
Both sides are present.
Yes, a caveat is there.
Only sole respondent, my lord, sole respondent. Actually, my lord, order 7 rule 11 application was dismissed. So let it be admitted and come for admission stage, my lord. Because only order 7 rule 11 application was dismissed, yes.
We'll admit it
It
then.
will be, yes, finally heard
Hmm.
on the motion, admission stage.
Both the parties are present. List this matter for admission. Meanwhile, call for the scanned copies of the trial court record.
Oblige, lord. Oblige.
Meanwhile, call for the scanned copies of the trial court record. List on 19 September.
Item 6.
Net neglection. Petitioner filed this instant petition on against the order dated 25/2023 and 5/5/2020.
You got to go up a little.
Hello, the petitioner filed this instant petition against the decided matter, my lord.
petitioner filed 3 numbers of petition, my lord.
Hmm.
One petition number 233/2020,
Hmm.
that was, my lord, mistakenly withdrawn. Then against of that, petition number 1858/2021, dated 1/10/2021, my lord, filed, but enclosed the photocopy. And that is why, my lord, annexure 3, page 58, 59, my lord,
Page 59,
58, 59, my lord,
58, 59.
58, 59, my lord, that order was rejected on the ground that document was not enclosed. Against of that, my lord,
Hmm.
filed the review petition.
Hmm.
Actually, my lord, against that order, my lord, a reversal and modification petition should be filed, my lord, but mistakenly filed the review petition, my lord. Yes, yes, I filed this instant petition against the review petition order dated, my lord, 5/5/2025, for praying for setting aside this order and to allow the petitioner to file the a liberty may be given to file the petition for modification. my lord. This is my humble prayer.
Page 58, 59.
58, 50.
Which is the impugn order at which page?
Impugn order is page, my lord, 58 to 65, my lord. And a review order is, my lord, page 5/5/2025, page, my
You
lord.
want a stay, interim stay, or should I issue notice? Or you want me to pass an order at the motion stage?
Order may be passed, my lord, to liberty be given.
Actually, I
to file
couldn't
the
follow you what
petition.
you were submitting actually. I couldn't follow what you were submitting. I'll read it and then I'll
Then
come
you
back
do-
to you after some time.
Absolutely.
Okay?
Nothing.
Have you filed this petition during the period of limitation?
My lord.
This order was
Within the
passed
period.
in the year 2023.
No, that is the one of the earlier order. Against of that order, my lord, file the petition, my lord. Petition number 1360. Filed on, my lord, 1/7/2023. Against of that, my lord, said petition has been filed on, my lord, 26/6/2025, my lord, within a period of limitation.
Which page?
My lord.
Which page?
The petition is not enclosed, my lord, and petition number is there, my lord, in page number 60, my lord.
Okay, okay. All right.
My lord.
Yes, yes. Okay. You want me to, this order cannot be set aside because this order is correct.
Madam.
So I can direct you to file a review petition before the appellate court or before the, what type of, are you asking for?
Lordship could make a direction to file a fresh petition for reversal and modify the order by the honorable
Fresh
court
petition for reversal.
for reversal and modification.
No, but this has been correctly passed. This order has been correctly passed.
Madam.
What is your prayer?
In the review, prayer is, madam, my junior has drafted this matter for setting aside and quashing the order related to orders. That will not set aside, madam. That will not set aside.
This has been correctly passed.
Madam.
I can issue notice and hear you. I am not passing any order. This order has been correctly passed.
And that decided two orders is enclosed along with this petition is annexure 1 and 2, my lord.
Sorry?
There's decided two orders, my lord, against of that whose petition was filed for discard and dismissal the present title suit, my lord.
Just check the prayer. I'll just check the prayer.
Madam.
I can dismiss it at best. I'll issue notice or I'll dismiss it.
I'll issue the notice, madam,
I'll issue notice. Okay.
at this stage.
Learned Counsel Mr. B. Islam is present for the petitioner. Issue notice to petitioner to take steps to issue notice to the respondent returnable in 4 weeks. Meanwhile, call for the scan copies of the. Do we need the scan copies? I don't think so. We will require scan copies.
Very big voluminous, madam. Voluminous matter, madam.
It's not required, actually. Returnable within 4 weeks, list accordingly. Item 7.
20.
May please your lordship. My lord, the present petitioner has challenged the order dated 29/5/2025 at page 48, whereby confirmation for substitution has been rejected. My lord. The factual background is that, my lord, petitioner's father and other the defendants in a suit filed by the opposite party. Opposite party suit was decreed. Then, my lord, the defendants, including the father of the petitioner, filed an appeal, title appeal before the civil judge senior division. Then that appeal was disposed of on 19/9/2015.
Who had filed the appeal? The petitioners.
Appeal filed by the father of the petitioner along with the other defendants.
Okay.
Petitioner father was the one of the
Petitioner were the defendant in the original suit. The
Yes,
petitioners.
yes. Petitioner is not the original suit,
father.
petitioner father of the original suit. That, my lord, the suit was decreed, then the father along with other defendants filed an appeal before the civil judge, and that appeal was disposed of on 19/9/2015 to pass a fresh order, directing this trial court to pass a fresh order. And that order was challenged by the plaintiff opposite party before this honorable court as a second appeal, SAO, that is number as SAO 9/2016. And that was disposed of, that second appeal was disposed of on 22/3/2022. And the petitioner father expired on 23/7/2020. My lord, after disposal of the second appeal, there was delay to receive the records by the appellate court, first appellate court. And in the meantime, father expired on 23/7/2022. Father could not be substituted in the second appeal. And since there was delay in receiving the records, that cannot be done within a limitation. And the record, after receiving the record, the first appellate court fixed the case for appearance on 19/9/2024.
It was remanded back.
It was remanded back to the first appellate court to pass a fresh order. And on 19/9/2024, the first appellate court fixed the case for appearance of the parties. And condonation petition was filed on 13/3/2025.
We'll have to issue notice.
My
We'll
lord,
have to issue notice.
unless, my lord, the stay of the proceeding, my lord, there may be.
That is it has been remanded back in the year 2024,
My lord,
not very long ago. We'll issue notice.
my lord,
It will not be disposed of so soon, so early.
no, at least is, we are not praying for disposal. Lordship may
No,
call
no,
for-
that case won't be disposed of so early.
Not disposed.
We'll issue notice within short date, and then let's see if meanwhile we can file, we can order for stay. Let the other side come. Short date.
My lord, the next case is, next date is fixed on, I think, October. Time is there in October. This
October, so before, which date of October? Before that, we'll fix a date.
is, that date is fixed on October. So for my information. Lordship, may they give a fixed date, a short date, my lord?
Yes, short date. I'll
We'll-
fix date. Before any date in October.
No, my lord, before October it will be. Should be
Before October, okay, yes.
September in the last, in the
Last
latter
week of
part of the
September.
September, my lord.
Yes. Council Mr. A.K. Sigdar is present for the. A.R. Sigdar is present for the petitioner. Post of petitioner to take steps to issue notice to the respondent, returnable on date of the option. Respondents, returnable on 23rd September. List on 23rd September.
My, deep love bless.
Item 8. Nine.
Lordship, I was the plaintiff in a title suit, Your Lordship. Filed for specific performance of his contract for an agreement for sale, Your Lordship. Total consideration was 4,14,000, 4 crore 14 lakhs rupees. Out of that, I have already paid 1 crore 13 lakhs. Thereafter, I filed this suit because they denied, and there were as many as 9 witnesses, listed witnesses, Your Lordship. As there were, out of the 9 witnesses, there were some official witnesses too, Your Lordship.
Title suit.
Title suit.
You have paid how much?
1 crore 13.
Agreement, out of the agreement.
Out of the agreement. Total
four
consideration was 4 crore
For
sale of a land, Your Lordship. Total was 4 crore.
Kamrup?
No, Lordship. It is a large plot of land, 4 bigha 3 katha, Your Lordship, in Borpeta. So out of 4 crore, I have already paid 1 crore. So there were 9 witnesses, Your Lordship, listed witnesses. So out of these 9 witnesses, there were official witnesses as well. So your lordship knows when there are official witnesses, we don't summon all the official witnesses on the same day. One official witness comes, he is examined and cross-examined, discharged, then the next is come.
Can someone if you want to?
That is the thing, your lordship. So when there were 6 official witnesses were already there, they were summoned. Lordship may come to page 49, your lordship. It is order dated 24/4/2025. Plaintiff and defendant are represented by the learned counsel. Same petition number so and so filed by the learned counsel for the defendants, they opposite party, stating that they have declined the cross-examination of the PW.
This is an impugned order.
No, lordship. This is just before the impugned order. The previous day. They have declined to cross-examine the PW. Heard the learned counsel for the defendant, learned counsel submits that they will not cross-examine the official witness from the Deputy Registrar Borpeta, PW6. Hence, the cross-examination of PW6 is declined by the defendants. Defendants is direct to pay cost on the next date. PW is closed, your lordship. Though there were other official witnesses, PW was closed. Immediately on the next date, 14/5/2025, I filed the petition, your lordship, which is at page 55, annexure 4. In this petition, I have said there were 2 bank witnesses as well after them, because I have paid some amount through bank transfer and I have to prove that through the bank witnesses, they need to be called, your lordship. They are listed witnesses. This petition was rejected by the court. The court said we have got sufficient opportunity to call the witnesses, but we did not call these 2 witnesses previously. Hence, and on the next date, immediately when we filed this petition, your lordship, the defendants have filed the DW1 just to prevent, and the court said since DW1 is already filed, we cannot call for more PWs, your lordship. The impugned order is at page 59. The court has observed certain dates when the case was fixed for PWs in page 60. But if your lordship calls for the scanned copy of the record, all this date the PWs were continuously coming and cross-examination was being done. Other PWs. We did not deliberately take any date or any adjournment on all these dates.
This case was pending since 2019.
19, your lordship.
And it was only
There were-
pending for evidence of PWs.
PWs,
You want me to
not
pass an
since
order
19,
now?
your lordship. From 23,
Without hearing the other side or
No,
should I
this
hear
time
the
issue.
other side? Notice. Issue notice. PWs are now DW cases.
DW, they have filed DW1, your lordship.
DW1.
Now, if it is continuing, then they will pray for cross-examination. At this stage, at least the proceeding may be stayed, your lordship. I am the plaintiff. Stay will suffer. I will suffer for the stay, but I'll have to pay for that, your lordship.
Yeah, you will suffer from the state.
Because if they continue the cross-examination of the DWs, it will come to final argument without these PWs being examined, your lordship, the bank witnesses.
This case is pending at the stage of DWs, and how many DWs they have?
They have filed
listed?
DW1 only. They have filed
And
the
according to the list, how many DWs they have
3
listed?
DWs.
3 DWs. Okay, we'll stay there. Third learned counsel, Mr. B.J. Mukherjee. B.J. Mukherjee for the petitioner. Mogdam Ali, who has filed his application under Article 227 of the Constitution of India, as is agreed by the impugned order dated 4/8/2025. Which page? You have just
Order
told me
dated-
the page.
page number 59.
51.
59. Annexure 6.
Passed by the learned Civil Judge Senior Division, whereby the petition under Order 16 Rule 10 of the CPC for summoning listed witness of the plaintiff was rejected. It is submitted on behalf of the plaintiff that the plaintiff's case, that the plaintiff will be highly prejudiced if 2 official witnesses, who are they? 2 official
The
witnesses?
branch manager of SBI
I-
BB Road,
The
Borpeta.
branch manager, comma, and the
Both are branch manager. Branch manager
Oh.
SBI BB Road, Borpeta branch and SBI Bajar branch.
are not examined as witnesses. Full stop. It is submitted that although the learned trial court has observed while passing the order that the plaintiff has procrastinated by the case by not adducing evidence on several dates, yet the trial court records, if called for, will reveal that the plaintiffs have been regularly examining witnesses, including the official witnesses, at regular pace, and there was no bona fide and procrastination on the part of the plaintiffs. It is further submitted that this case is at present at the stage of examination of the defense witnesses. Full stop. It appears that an interim order of stay may be granted at least till the next date of listing. Call issue notice to the how many respondents?
They're all substituted respondent. 7, Lordship. 7. 7 respondents.
7 issue notice to the respondents returnable within 4 weeks. Meanwhile, the so this order I'll stay then, although it's fixed for the or impugned order dated 4/8/2025. The proceeding will stay the proceeding.
Lordship, proceeding.
But it will be better. Impugned order nalage. Meanwhile, the proceedings of TS 60/2019 is stayed till the next date of listing. Call for the scan copies of the trial court records.
May it please your lordship, lordship, kindly pass over the matter for the day, lordship. Conducting counsel is.
Learned counsel Miss
B. Debbie, lordship.
B. Debbie, on behalf of, oh yes,
My name.
your name is there, has prayed, has requested for passing over the matter for a day.
Deeply.
Okay, date asin ye, date asin hello, kung date. 13 September 30. We'll send it for local or mediation.
My lord, the mediation is probably not possible. That is my understanding because there is a ground on competency.
No element of settlement.
My lord, because my learned senior will be able to address this better because in the
Yes, this
appeal numbers.
if there is no element of settlement, then we
Lordship,
will proceed with the contested proceedings.
my submission will be, Lordship, in this particular case, claim has been filed by daughter of the deceased, and daughter is already married, and she is living with her husband. So she cannot claim dependency for death of her mother. That was the ground for appeal. And in the petition, in filing of appeal, there is a delay of 197 days delay in preferring appeal. And I have suggested it to make a compromise. If that is possible, then we are agreed to pay some amount. Because under conventional rates, he is entitled to some amount as well as interest. I propose to give some amount, but whether he has taken the instruction or not, I do not know. So,
My lord, my instruction is to contest the matter, but because there are certain parts in our statement, I am been instructed to intimate the court that she has said in her evidence that she was staying with the father. Her husband was ailing, and the father was actually taking care of the family, and the entire family was staying with the father. So that was my instruction, which I have received orally even the matter. So my lord, on the issue of dependency, my lord, which the issue which reveals around this appeal, my instruction is that she is actually dependent upon the father. She was dependent on the father. Her husband was ailing, and her husband is actually ailing. He doesn't do anything as such, not regular basis. The father was only taking care of the family. She, at the time of her marriage, the father had taken certain loans for the girls to get married. Now, after the death of her father, that particular loan amount is also upon her too.
So my
No,
submission.
this will not come in back appeal.
No, my lord, I understand, but my instruction, my lord, is I'm facing. No, I understand, my lord. Just that she was dependent upon the father. That was my instruction, my lord. And they have asked us to.
So in this particular case, my submission will also for the benefit of the claimant. If delay is condoned in filing appeal,
We'll condone
matter
the delay.
will be listed for admission, and then we will pay some amount. He will get that amount.
50% maybe, my lord, deposited
Today,
and.
this is not for admission. This is for delay.
Let us condone the delay.
My lord, I
and
not,
we'll
if
proceed.
my learned senior is depositing, I'll.
And if you are agreeable to look at it, then I can fix it for.
My lord, if.
Lordship will fix for admission. Delay may be condoned and Lordship will fix for admission. We
Alright.
will go some amount.
Deposit.
Huh? I'll fix it. I cannot fix it for admission also. I'll have to fix it for registration of MAC case. MAC case has not been registered.
No, MAT appeal will be registered subsequently. Lordship, at least the delay will be condoned.
Yes. Learned counsel Mr. S.K. Gusami, no?
Yes, sir.
Is present for the petitioner. Applicant, petitioner or applicant. Applicant stroke appellant.
197 days delay, Lordship. And claimant itself appeared. So Lordship with
Learned counsel Mr.
AB Day, my lord.
A.B. Day is present on behalf of the claimant.
Respondent.
Respondent
One. Full stop. This application is under Section 5 of the Limitation Act with prayer for condonation of delay of 197 days in preferring the appeal against the judgment and award dated 2/2/2024 passed by the learned member MAC T. Kachar Silchar in MAC case number 90/2021. It is submitted on behalf of the applicant that there was no mala fide on the part of the applicant. The delay was owing to
obtaining certificate copy and sending the record to the regional office at Guwahati.
obtaining certified copies and
Hey.
sending the record to the
Regional office at Guwahati
regional office at Guwahati.
from Silchar.
Regional office at
Guwahati from Silchar.
regional office at Guwahati from Silchar. To stop sufficient grounds have been shown after a comma and to stop delay. As sufficient grounds have been shown, comma. Delay is condoned after hearing the submission of both the sides. Receive to register the connected.
My lord, I'll praise something, my lord. If that matter can be listed after probably 1 or 2 weeks, my lord, that will be little convenient, my lord. If it is-
Registry will, you'll
my
have
lord,
to.
this, my lord, I will. Like,
Any scope of mediation, this
There is
mediation
no
drive.
possibility
National
because
mediation
appeal and
drive.
cross appeal is there. So there is no possibility of mediation, Lordship. I am a dispose of Lordship. We have no objection. Condonation of delay 29 days. And main appeal may be listed. Lordship.
Hard learned counsel Miss
S. Sodri.
S.
Sodri on behalf of R.K. Bhatra.
On behalf of
Say R.K. Bhatra.
S. Sodri. On behalf of learned counsel Mr. R.K. Bhatra, representing the appellant stroke applicant. Full stop. This application is filed under Section 5 of the Limitation Act with prayer for condonation of delay of 29 days in preferring the connected appeal. Full stop. Learned counsel Mr. M. Khan, representing respondent number 1 to 5.
1 to 5.
Has submitted that there is no scope of settlement and matter may not be referred for mediation. Full stop. However, he has raised no objection against the prayer for condonation of delay. Learned counsel Mr. K.R. Padgiri, appearing for respondent number 6 to 7, has also no objection if delay is condoned. Full stop. It appears that there is no mala fide in and sufficient grounds have been shown. Full stop. The delay was owing to the information forwarded to the regional office. Full stop. Considering all respect, delay of 29 days is hereby condoned. Registry to register the connected appeal.
But in the appeal, Lordship, our name may be shown, Lordship. And
to reflect the name of Mr. Your name is already there.
No, in IA, Lordship, that has been reflected. But in
Okay.
appeal,
Mr. M. Khan and Mr. K. Padgari as representing the respondents in the cause list
While the appeal is listed, otherwise lordship,
when the appeal is listed.
and a copy of appeal memo lordship, direction.
Whose soft copy of appeal memo to be furnished by the appellant to the respondents.
Item number 48 of the supplementary for this.
This is your lordship. Lordship, there is a delay of 427 days in filing the appeal, lordship. Last time, Mr. Day wanted the case to go to Lok Adalat. Lordship, the delay may be condoned. After that, it can go for Lok Adalat because Lok Adalat is on September 13th. The other respondents, they were sent to notice, has not yet come back, lordship. It can be deemed, sir, because again, if it is not settled in the appeal, again notice will go to them, lordship.
My lord, the conversation was in this way, my lord, because there is no stay petition in this case, my lord. And the delay explained, my lord will see the
Petition we can file anytime, lordship. Thing is, many a times we do that we file the delay because in delay the notices are here. This stay petition I can file tomorrow also. There is no impediment in that. But the thing is, if it goes to Lok Adalat and if it is settled in Lok Adalat, there is no use of admission of the appeal or the only the delay may be condoned. That is,
if I may, my lord, for one sentence, my lord, if I may say, my only worry was this, my lord, that I am 75 years old, my lord. If there is an actually good fit attempt with the insurance company, then I will agree for the delay to be condoned and my lord can send the matter to the Lok Adalat and I will try to settle the matter. I'll instruct the people to come down and.
We'll find out on 13th.
My lord.
We'll find out on September 13th.
My lord, because my leg is broken, my lord. My
13th of Lok
I understand.
Adalat,
No, it was-
that is what
but my
lordship
lord,
is
I have to call the client, my lord. That is my only problem. My client, that the claimant here, had broken his leg.
Please.
Before lordship calling, he can have
That is my lord.
pre-settlement talks with the insurance company as a
That-
he
Not
knows
done
that.
nowadays.
That, my lord,
Yes.
if I may address, my lord, for a moment, that may be done without condoning the delay also, my lord. That is my prayer.
Then
I will take an attempt, my lord, no problem, because, my lord,
No, lordship, it came up on 29/8. We were asked to take instruction and with the
on the point that
condonation
if there is
of
50%, they are supposed to deposit. That was the also suggestion given by the court. I said that, yes, I'm agreeing. Let the 50% be deposited and let the matter be go for the local. We will see what comes out of it.
appeal is not yet listed, not yet numbered. How can we deposit?
Otherwise, my lord, I will check. My lord, if my lord wants, I will go to the insurance company and I will ascertain, my lord, with the insurance company if the matter can be settled. That can be done at the stage of IA also, my lord. There is no reason for.
Lordship, the delay may be condoned. Why?
My lord, my
delay because 29th it came. That day he first time submitted that it can go to Lok Adalat. We took time to take instruction, lordship. If there today I'm coming with
let us fix it for well,
Lok Adalat, my lord, I
give
will.
you a short date. I won't fix it for Lok Adalat. I'll give you a
My
short
lord,
date.
yes, my lord. I will get
Then
short date, my lord.
You
I'll meet insurance company immediately, my lord.
yes. You obtain instructions or you
I'll meet my lord insurance
meet the
company.
insurance company.
I'll have one more.
When should I
Any date, my lord will suggest, my lord, I'll go in.
list is
but
8 September, my lord. I will do that.
No, I won't be there, lordship. I'm going to Aizawl for a mediation training, lordship. So let it be after that, lordship. Say from 15th, lordship.
15th it is. Any date,
15th.
my senior is convenient.
Or lordship on 9th. I'll be back on 9th, Tuesday.
15th of no, it's September 13th of Lok
13th.
Adalat.
Oh, Lok Adalat.
Yes.
9th maybe, my lord. 9th.
Yes, on 9th. Yes.
I will attempt.
As agreed by learned counsel for both the sides, list this matter on 9th September.
Deep problem, my lord.
Item number 12 for admission.
Me, please, my lord. My lord, the learned trial court had passed an order allowing the amendment application of the respondents. Against the same, this civil revision petition has been filed. If I am allowed to state the facts in brief.
No, you see, we'll hear you throughout. We'll hear you and we'll
For disposal, my lord.
yes.
I'll be arguing for disposal.
Because if you submit, if the submission is for admission, it is as good as hearing the matter.
No, my lord,
completely.
we both parties agree to it. My lord may dispose it of today.
Yes.
We'll make our complete. May I begin, ma'am?
Yes.
My lord, the petitioners were originally plaintiffs in title suit number 13 of 2007, later renumbered as title suit 125 of 2007. The said suit
Earlier, what was the original PS number?
13 of 2007,
13 of 2007, renumbered as?
125 of 2007.
Okay.
Before the Munsif number.
Itu very minus apa pa? 125 of 2017. Yes.
My lord, the petitioners were the plaintiffs there. Petitioners as plaintiffs has preferred a suit under section 6 of the Specific Relief Act, seeking a recovery of possession from the respondents.
Recovery of possession of?
From the respondents, madam, as defendants. They were arraigned as defendants. The defendants appeared in the suit. They filed their written statement in the year 2008, along with a counterclaim was also filed by them. In the suit, the plaintiffs had contested that by way of certain by way of distinctly two sale deeds, they had bought a portion of 3 kata 9.5 lechas of land, and in a portion of that land measuring 3 katas, which is the suit land, the defendant had entered into possession. One of the defendant, by filing the counterclaim, had challenged the said two sale deeds which were relied upon by the plaintiff, and the Honorable Trial Court had disposed of the title suit, in the year 2016, whereafter a CRP was preferred, my lord. In the CRP, it was held that with regard to the part of the plaint, wherein the prayer was with regard to section 6 of the Specific Relief Act for possession, that part was upheld, and with regard to the right title in interest, as had been raised by the respondents, that part was remanded back to the trial court to be decided, along with fresh recasted issues. To consider the right title, interest, and possession in respect of the suit land, that was the very specific recasted issue, and the court was asked if any other issue in this regard is necessary. It may be framed, and the suit should only be decided with this particular point in mind, which was raised in the counterclaim. As the suit of the plaintiff was decreed and it was also upheld in the revision petition, the plaintiffs had moved ahead with the execution petition, wherein the respondents were also present. And on 7/10/2017, my lord, the decree was executed and possession was handed over by the AGs of the court from the respondents' defendants in favor of the plaintiff petitioners. Now, my lord, what was necessitated is that thereafter, since they did not have a possession in their counterclaim, they did not have a prayer for recovery of possession. That is understood. But this possession was transferred in the year 2017. Against that, in the year 2022, they filed an amendment application stating that there is a need for two prayers. One, they want to insert the fact, the wider paragraph that on 7/10/2017, the possession was granted to us in with regard to the execution petition, and thereafter they wanted to add two prayers, 4 prayers, majorly two, with regard to declaration of right title in interest of the defendant and recovery of possession from the plaintiff. My lord, if comes to the amendment application, which is at page 65 of this revision petition. Well, the relevant portion would be from page 69 onwards.
Okay.
My lord, herein, if I'm allowed to read 2 paragraphs, madam. 10. That the learned court has executed a decree passed in title suit number 13 of 2007 on last 7/10/2017 by delivering the possession of the suit land to the plaintiff's decree holders. As a result, the plaintiffs are now in possession over the suit land after execution of the aforesaid decree on 7/10/2017. even though the defendants were in possession of the suit land until the execution of the decree so made. This shows that they were, the fact that it could not have in any practical manner been so, they have knowledge of the facts since 7/10/2017. But this.
So you are for the defendants.
I am for the plaintiff, my lord. They are for the defendants. They are seeking amendment in their counterclaim. This very fact was within their knowledge from 7/10/2017, but this amendment application was filed only on 9/11/2022. That is after a period of almost 5 years.
Okay.
In the succeeding page, my lord, page 70, paragraph 14, my lord, finds the proposed amendments which were suggested by the respondents in the counterclaim.
So amendment application was filed on which date?
9/11/2022.
Page, what about page 70?
Page 70, my lord, from paragraph 14 onwards, these are the proposed amendments which they
Okay.
suggest to
Alright.
introduce into the counterclaim. My lord, after the amendments are suggested, interestingly, my lord will find that no aspect as to why the delay was caused in filing this amendment application from the year 2017 till the year 2022 has been mentioned. Not even a whisper or a word has been stated what stopped the counterclaimants or respondents from making a prayer before the learned trial court within the period of this 5 years, and why there was an inordinate delay of 5 years. On these aspects, my lord, an objection was also filed, and the learned trial court allowed the amendment application by order dated 31/5/2023, which is annexion 9, my lord. My lord would find the relevant portion from page 81 onwards of the order, of the impugned order.
This is the impugned order.
Impugned order, my lord, annexion 9. From page 81 onwards, my lord finds the relevant portion.
Okay. Yes.
Second paragraph, I have heard both the sides and considered the submissions put forward. On perusal of the case record, it transpires that after the order passed by the Honorable Guwahati High Court in CRP number 483 of 2017, issues were framed to ascertain the right title, interest and possession of the suit land, and the matter is at the stage of evidence of counterclaimant of defendants. But during the proceeding of the case, execution proceeding was initiated with respect to the decree passed in title suit number 13 of 2007, and eventually the possession of the suit land was handed over to the opposite party plaintiffs. The opposite party plaintiffs have asserted that proviso to order 6 rule 17 states that no application for amendment shall be allowed after trial has commenced. At this juncture, it is pertinent to mention that the Honorable Supreme Court by the number of judgments has observed that a procedure is a handmaid of justice and not the mistress. The rules of procedure are made to advance the cause of justice and not to defeat it. Construction of the rule or procedure which promotes justice and prevents miscarriage has to be preferred. The last paragraph. At the same time, it is also noted that the possession of the suit land was delivered to the opposite party plaintiffs on 7/10/2017, and the instant amendment petition was filed on 9/11/2022. This fact was very well recorded by the learned trial court. The petitioner defendant number 1, 2, 3, 4, 5, 6, 7, 8, and 11 with due diligence could have filed the said petition much earlier, avoiding delay in the proceedings of the case. My lord, even after this, taking this observation into account, the learned trial court proceeded to allow the amendment application. Therefore, a challenge to the said order is on 3 counts, my lord. First and foremost, the proviso which was introduced in the year 2002 to Rule 17 of Order 16, that was not taken into consideration. Even if it was allowed, the mere fact of a delay of 5 years with no whisper of a word was made there as to why they could not approach the court before the period of 5 years. There is one thing to say that the delay may not be acceptable, the submissions or the statements with regard to the delay may not be acceptable. But here in this particular case, as I have shown from the annexure, not even a word was mentioned as to why the delay had occasion. Well, in that respect, I would just take your lordship's notice to Rule 17, the proviso with this states.
It was very CPC.
CPC, madam. Order 6, Rule 17.
Yes. Order says Rule 17 proviso, yes.
My lord, otherwise the provision provides that these pleadings may be amended at any stage. However, the provided that no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that in spite of due diligence, the party would not have raised the matter before the commencement of trial. My lord, here it has been already recorded in the judgment allowing the amendment that trial had already commenced since the suit was at the stage of filing of evidence by the opposite party or plaintiffs. And it was also noted in the very same order that that with due diligence, the respondents could have filed the said application much earlier. And since these are recorded here, a direct reading of the proviso shows that the order is in contravention of the provisions of the proviso. But I will rely upon a few judgments.
Yes.
2006,
Yes, yes.
12 SCC.
2012.
It's 2006, 12 SCC 1. My lord,
2006.
Ajendra Prasad ji and Pandey and another versus.
Yes, yes, yes.
Yes, my lord. My lord, I rely on paragraph number 53 at page 10. Page numbers are mentioned at the top.
Paragraph?
53. Second paragraph from the bottom.
Page?
10.
10, okay. All right.
In our opinion, the facts above mentioned would also go to show that the appellants are lacking in bona fide in filing this special leave petition before this court. It is also to be noticed that the High Court has recorded relevant point in its elaborate judgment dated 5/10/2005 and have been dealt with despite the opposition of the contesting respondent that these pleas were not taken in the written statement. Under these circumstances, non-seeking of appropriate amendment at appropriate stage in the manner envisaged by law has dismantled the appellants to any relief. The amendment, in our view, also seeks to introduce a totally new, inconsistent case. We have carefully perused the pleadings and grounds which are raised in the amendment application preferred by the appellants at Exhibit 95. No facts are pleaded nor any grounds are raised in the amendment application to even remotely contend that, despite exercise of diligence, these matters could not be raised by the appellants. Under these circumstances, the case is covered by the proviso to Rule 17 of Order 6 and therefore relief deserves to be denied. The grant of amendment at this belated stage, when deposition and evidence of 3 witnesses is already over, as well as the documentary evidence is already tendered, coupled with the fact that the appellant's application at Exhibit 64 praying for recasting of the issues having been denied, and the said order never having been challenged by the appellant, the grant of present amendment as sought for at this stage of proceedings would cause serious prejudice to the contesting respondents, original plaintiffs, and hence it is in the interest of justice that the amendment sought to be denied and the petition be dismissed. Well, these were the arguments advanced. At para 59, my lord, of this page, the second paragraph from bottom.
The above averment, in our opinion, does not satisfy the requirement of Order 6, Rule 17 without giving the particulars which will satisfy the requirement of law that the matter now sought to be introduced by amendment could not have been introduced earlier in respect of our due diligence. As held by this court in Kailash versus Nanko and others, the trial is deemed to commence when the issues are settled and the case is set down for recording of evidence. My lord, in this case, a suit after remand had reached the stage of filing of evidence and issues were already casted. So trial had already commenced in this case. And moreover, they had not shown anything on record or pleaded anything in their petition for amendment to show that despite of exercise of due diligence, they could not have
So it was at the stage of, after remand, it was at the stage of evidence.
Yes, my lord, that is very well
Evidence by this on
by us,
claim.
by us, my lord, by the plaintiffs
Okay, on the counterclaim.
on the counterclaim. That is very well recorded in the.
Did the evidence commence?
No, my lord. No. However, my lord, trial has to be commenced because issues have already been framed and the case has moved to the stage of evidence.
Yes.
My lord, next I'm relying on my lord, Vidyabai and others versus Padmalatha and another. 2009 to
This one you're relying for this stage, no? This case,
state as
2000
well as the fact that they did not show that despite due diligence, they could have brought the same said application for amendment at an earlier stage. And this
Yes,
is very well recorded in the assailed order of the trial court as well. The trial court has very well observed in clear words that they could have brought it before at an appropriate stage at that right. 2009 to SCC 409. Vidyabai and others versus Padmalatha and another. Not here from page 4, para 7, second paragraph from the top.
Page 4?
Para 7, my lord. Fourth line from the top.
Para 4, no?
Para 7, my lord. Page
Para 7.
Very good. By reason of Civil Procedure Code Amendment Act 2002, the Parliament inter alia inserted a proviso to Order 6, Rule 17 of the Code, which reads as under. I have read it, my lord. I will not bother, my lord, with that. It is couched in a mandatory form, my lord. This is important. Couched in a mandatory form. The court's jurisdiction to allow such an application is taken away unless the conditions precedent therefore are satisfied. Namely, it must come to a conclusion that in spite of due diligence, the parties could not have raised the matter before the commencement of trial. My lord, in the order which the petitioners have assailed, this criteria was not at all considered because very well it has been observed in clear words, but the judgment, the amendment was allowed. So this is against this what has been held in the judgment. Now, next paragraph from the order passed, it is evident that the respondents had not been able to fulfill the set precondition. The question, therefore, which arises for consideration as to whether the trial had commenced or not. In our opinion, it did. The date on which the issues are framed is the date of first hearing. Provisions of the Code of Civil Procedure envisage taking of various steps at different stages of the proceeding. Filing of an affidavit in lieu of examination of chief of the witness, in our opinion, would amount to commencement of proceeding. So, my lord, since issues are framed, the trial had already commenced in the case at hand as well. In this case law, my lord, the Apex Court also holds that trial had commenced at the stage of framing of the issues and that the proviso to Order 6, Rule 17 is of mandatory form.
Yes.
Well, on the next page, page 5, in the middle section, the Salem Advocate Bar Association has been
Hmm.
quoted, my lord. We have carefully considered the submissions made by the respective senior counsel appearing for the respective parties. We have also carefully perused the pleadings, annexures, various orders passed by the courts below, the High Court and of this court. In the counterclaim filed by the respondent number 1, various dates of hearing with reference to the proceedings taken before the court has been elaborately spelled out, which in our opinion would show that the appellant is precluded by the proviso to rule in question from seeking relief by asking for amendment of his pleadings. It is to be noted that the provisions of Order 6 Rule 17 have been substantially amended by the CPC Amendment Act 2002. Under the proviso, no application for amendment shall be allowed after trial has commenced unless, in spite of due diligence, the matter could not be raised before the commencement of trial. It is submitted that after the trial of the case is commenced, no application of pleadings shall be allowed unless the above requirement is satisfied. My lord, in this manner, the amendment in this case was rejected. I will not go through all the paragraphs. I've already provided it. So this is my first limb of argument that as per the statutory provision of Order 6 Rule 17 and the proviso contained therein, there is an embargo after the amendment of 2002 which they have to fulfill, which has not been fulfilled, and it is evident from the fact that the learned trial court has also observed in the order that it has not been fulfilled. It contains of two conditions. One, trial ought not to have commenced, and if trial has commenced, they are to show the respective parties are to show that despite exercise of due diligence, they could not bring it before, they could not have introduced the amendment before the stage of trial, which is not the case in the present scenario. The next limb of my argument, my lord, is the fact that they are trying to introduce a time-barred claim in this by way of amendment, a prayer which has already been time-barred. My lord, at page 71, amongst the prayers which they choose, which they have sought to introduce, sorry. I'll just read out the prayers now. The prayers which they have sought to introduce, the first prayer is, my lord, for a declaration that the defendants number 1 to 9 have right title and interest over the suit land in schedule B and C, and the plaintiffs have no right title and interest thereover. In this regard, my lord, I would pray to rely upon the Limitation Act, my lord, Article 58.
Yes.
It states that to obtain any other declaration, the period of limitation is 3 years and it commences from when the alleged when the right to sue first accrues. Now, the right to sue first accrued at the time when the suit was filed in the year 2007. The plea of right title and interest was already taken by the respondents as defendants both in the written statement as well as in the counterclaim, which were filed in the year 2008. Since then, they were very well aware of the fact, since they were already contending about the right title and interest, it was a necessary corollary. They asked for these reliefs at that very stage. They came to know that I am asserting my right over the land, though my suit was only for with the prayer of possession, but elements of pleadings with relation to right title and interest were already there in the plaint. And after the civil revision petition casting this very issue, the suit was remanded back to the trial court to decide on this issue. From the date of filing of the WS, even assuming that from the date when the case was remanded back by the trial court on 9/1/2017, since then, my lord, the 3 years have long passed with regard to this particular claim. If I am to rely on Article 58 of the Limitation Act. And thereafter, they're trying to introduce a time bar claim in the manner of in the manner of an amendment. I will just rely on a last judgment manner to decide. 2022.
According to you, that when the WS was filed with counterclaim, the limitation runs, or when the suit was remanded back.
My lord, in my humble submission, when when WS with counterclaim was filed, because they have already taken the pleadings with regard to right title in interest and substantially shown that they have bought the land by various sale deeds and the mutation was done. In the written statement as well as the counterclaim, they have taken up these pleadings. But only two players were made in the counterclaim. One to cancel my sale deeds and second to uphold their sale deeds as legal and valid. To SCC online. SC 1128. Well, here in this case, I will just rely on paragraph 70, which is the
There's a recent judgment.
recent judgment, my lord.
Yes.
My lord is perhaps aware of this judgment as well.
Yes.
At page 18,
I've downloaded it from the live law. Page, which page?
page 18, my lord. Page numbers are at the left corner of the top. Para 70.
Hmm.
Dear my lord, it has been postulated under what circumstances? My lord, 70 Roman 2. All amendments are to be allowed which are necessary for determining the real question in controversy, provided it does not cause injustice or prejudice to the other side. This is mandatory as is apparent from the use of the word shall in the latter part of Order 6, Rule 17 of CPC. That is the proviso. The prayer for amendment is to be allowed if the amendment is required for effective and proper adjudication. But on the next page, page 19. Married Miller. Roman 2 clause C states that the amendment does not raise a time-barred claim resulting in divesting of the other side of a valuable right accrued in certain situations.
Roman 2 clause?
C, my lord, on page 19.
A
At
paragraph?
the top portion. To avoid when amendments are to be allowed. Amendment does not raise a
Which
time.
paragraph?
My lord, I will read from the very first line. It's to avoid multiplicity of proceedings provided the amendment does not result in injustice to the other side. By the amendment, the party seeking amendment does not seek to withdraw any clear admission made by the party which confers a right on the other side. My lord has.
No, can't find out. Which paragraph?
My lord, the very top of the portion, my lord, on page 19. Paragraph 70 continues.
Okay.
In Roman, it has been
Yes,
mentioned, Roman 2.
Yes, yes.
Roman 2 clause C. The amendment does not raise a time-barred claim resulting in divesting of the other side of a valuable accrued right. And thereafter, my lord, at point number 9, Roman 9, beneath, delay in applying for amendment alone is not drawn to decide where the aspect of delay is arguable. The prayer for amendment could be allowed. My lord, in this case, for the delay to be arguable, there had to be had been an explanation as to why the delay was caused. Nothing is mentioned in the application. The application was completely magnified and misconceived. That is all, my lord, I wish to submit.
Okay.
First, the rigors of the proviso of Order 6, Rule 17 were not followed, despite having clear observations in the assailed order that it was not followed, and they could have, with due diligence, raised this amendment at an earlier stage. Second, the delay which was caused in the amendment, not even in a single word or line, it was explained in the application by the respondents. And the third, my lord, is that a time-barred claim which has been long barred by time is sought to be introduced now against the petitioner plaintiffs by way of this amendment. These are the three counts on which the main challenge to the order for allowing the amendment has been made.
I have to check this judgment, my lord. So, my lord, day after tomorrow, my lord, just That may
Day
be.
after tomorrow?
Otherwise, my lord, during lockdown time was also there in between. Lockdown time was also there, my lord, 2000.
Oh, yes,
Yes, my lord,
That was there, but
that
nothing has been mentioned in the
and
petition.
so far, my lord, that was my lord, amendment petition was filed, my lord. Only because, my lord, in that petition, my lord, it specifically mentioned on the basis of the CRP, there was a observation, my lord, regarding the, if there is some issues are there, if you have to frame it. Because it is separately, it is a counter claim, my lord. I have already admitted here, my lord, that no, already, my lord, land has been already handed over to them. It is a section 6 case, my lord. So, my lord, on possession, dispossession, that is the only, my lord, issue. But already handed over the possession to them, my lord. Subsequently, in view of the honorable court's order, my lord, the said, my lord, observation as was there, my lord, in the CRP order. Thereafter, my lord, filed this petition and specifically mentioned that it is a, my lord, not mandatory directory and cost also imposed upon the defendant, my lord, that there is a, my lord, as it is delay, instant petition is allowed subject to cost of 5,000 to be paid the opposite party. And admittedly, I have already mentioned there in the petition that no, land has been already handed over. It specifically mentioned, and the learned court below also it is mentioned here that it is, though it is, my lord, it is mentioned, Honorable Supreme Court find a number of judgment has observed that procedure is a handmaid of justice and not its mistress. The rules of procedure are made to advance the cause of justice and not to defeat it. Construction of the rule or procedure which promotes justice and prevents miscarriage has to be prepared. In the all the judgment, it is specifically mentioned amendment is allowable even after, my lord, prior to disposal of the case. But this, as this is a separate issue, my lord, amendment petition or counterclaim was filed along with his petition, my lord, immediately after the filing the case, my lord, 2000. But as stage is different, he has not read. Here, my lord, I want to place, my lord, what has been here mentioned in the petition, my lord. Just I want to point out here, my lord. In the miscase application, specifically mentioned, my lord. Page 68, my lord. First up, my lord, page 67, that the defendant number 1 to paragraph 6, page 67. That the defendant number 1 to 8 being highly aggrieved and dissatisfied with the judgment dated 29/6/16 and decree dated 7/10/16 passed in TS number so by the learned court, prepared a civil revision petition 115 CPC as amended up to so before this honorable court, seeking appropriate relief in the matter. The honorable High Court had judgment and order dated 9/1/17 disposed the same by way of upholding the judgment 6 Reliefs Act and remanding the suit back to the court to decide the other issues, considering the respective right, title, interest, and possession in respect of the suit land, with further observation that the decree so upheld is liable to be executed in accordance with law, and that if any party is found to be entitled in possession in the suit land, it shall be within the power and jurisdiction of the learned court to be pass fresh decree to determine as to who should be lawfully in possession of the suit land. Here both the, my lord, parties have the dolils, my lord. That the defendant number 1 to 8 as a petitioners have preferred review petition under section 114, read with section so and so, as amended up to so and so, judgment and order passed in CRP number so and so by the honorable court in respect of upholding the judgment and decree passed in title suit number 13/7 by this learned court, while remanding the suit for adjudicating the right, title, interest, and possession in respect of the suit land, and in the aforesaid review petition number has been disposed of on withdrawal. That the plaintiff as decree holder initiated execution proceeding by title execution case number 3/17 before the learned court for execution of the aforesaid decree of recovery of the possession of the suit land. That the learned court executing court has executed the decree on last 7/10/17. He has admitted that 7/10/17 he has by delivery of possession of the suit land, and now in possession over the suit land after execution of the aforesaid decree on 7/10/17, even though the defendants were in possession over the suit land until execution of the decree so made, the learned defendants or the defendants in their counterclaims were not required to seek relief for possession of the suit land at the time of filing their counterclaim in view of the fact that they were in possession of the suit land till last 7/10/17, when the decree was executed by the delivery of possession of the suit land to the plaintiff decree holder. That in view of the developments so occurred after execution of the decree passed in the suit under section 6 of the Specific Relief Act, the defendants are required to amend the counterclaim for just and proper disposal of the suit and counterclaims in view of the subsequent developments so taken place. The defendants therefore propose following amendments of their counterclaim. The following statements may be added as a paragraph 5A of para 5 of the counterclaim filed by the defendant, that the plaintiffs and decree holders initiated execution proceeding entitled execution case number so and so before the learned court for execution of the aforesaid decree for recovery of possession of the suit land. The learned court as executing court has executed the decree passed in number so and so by delivery of possession of the suit land to the plaintiff decree holder. As a result, plaintiffs are now in possession of the suit land after execution of the aforesaid decree. Even though defendants were in possession of the suit land until the execution of the decree, the following additional prayer may be added in prayers for the relief as prayed for. B. For a decree of declaration that the defendants 1 to 9 have right title interest of the suit land in Schedule B and C, and plaintiffs have no right title interest thereof. For a decree of first possession of the suit land in Schedule B and C in favor of the defendant number 1 to 9, and the suit land be recovered to the defendants number 1 to 9 by evicting the plaintiffs and also by demolishing the structure thereon. So, my lord, according to me, my lord, as it was a separate, my lord, proceeding, my lord, out of the same title suit counterclaim, that was due to subsequent development after eviction, my lord, after, my lord, handing over the possession of the land, my lord, these issues have come and thereafter prayed for. Already I have mentioned, admittedly, it is a present position, my lord, but as there is not issue of title here, my lord, only possession and dispossession, section 6 case. That is why possibly learned trial court below, my lord, allowed the said, my lord, after long delay also, my lord, and cost has been imposed upon it, my lord, and specifically mentioned regarding that that it was a, my lord, procedural mistake, my lord, etc., my lord. So, my lord, in view of his, as he has submitted some judgment, my lord, let it be day after tomorrow, my lord.
Can it be on the 4th, my lord, if my learned?
Okay.
Okay.
No, sir, five minutes, five.
Okay. I got by now.
My lord, I'll reserve my right to reply after my
Yes,
learned concludes.
Learned counsel, Mr. N. Chaudhary has submitted his argument. Learned counsel, Mr. S. Das has submitted his argument and has submitted for time to place his argument on law points.
On,
all right?
yes, madam. All right.
List on 5th of September. It will very good. LCR call করা নাই. LCR is required in this case or not required?
It's required.
Trial court required?
It's required.
Required?
It's required.
Petitioner is also not represented, no? You are present for the petitioner?
Yes, Lordship, item number 14, Lordship.
Okay. LCR is required?
LCR, I think not required. This is only for amendment, Lordship. Amendment was allowed. Against that, I have preferred distribution petition, Lordship. We can take up the matter next week, Lordship.
Then meanwhile, we can call for the, not required.
Not required, Lordship.
Okay, learned counsel Ms. P. Bhattacharjee has submitted for time, has prayed for adjournment, list the matter next week, Divya. List the matter after 1 week.
Earlier stay order. That's it.
Interim order shall be, shall remain in force till the next date of listing.
Appellate.
Lordship, scan copy may be called.
You want?
Yes, no.
Okay, meanwhile, call for the scanned copies of the trial court records.
Obliged.
My lord, this matter may come up day after tomorrow, my lord. We have filed objection today morning, my lord. So that has to be come on record, my lord.
You want to go through the objection?
My lord, only thing is that execution case is fixed on 4th.
Then on 3, my lord.
So matter will, because records to be called for, matter, because without records, I think court cannot dispose.
Actually, they want to place their objection.
We have already filed, my lord.
They have filed objection, but you do not want to reply
They
on the
have served a
objection.
copy to us also.
Today we have sent my.
On third file, maybe on third file. Learned counsel Miss
P. Mishra.
P.
Mishra.
Mishra has prayed for time to place their submission on behalf of the respondents as they have filed an objection today. Learned senior counsel Mr. J. Roy is present. List the matter on 3rd September.
At 2 p.m. ma'am.
At 2 p.m.
2 p.m. I have some engagement in
Then
the.
3, my lord, not 2, 3. There's some 3.
3rd September?
No, 3 at 3 p.m. Not 2, my lord.
All right. Okay. At 3 p.m. Item 16.
Appeal by the insurance company, let's say. In this case, the disease was a pillion rider, and the insurance policy was a act policy, let's say. 3 vehicle was involved, let's say. 3 vehicle was involved in the accident, and in the instead case, let's say, liability was fastened upon the insurer of the motorcycle. In analogous case, in another analogous case,
You are the insurance company.
yes, sir. I am the insurer of the motorcycle, let's say. 2 vehicle was involved, let's say. In another analogous case, let's say, liability was fastened upon the insurer of other 2 vehicle. But in the instant case, the liability was fastened upon the insurer of the motorcycle. And the policy of the motorcycle was an act policy, and it does not cover the risks of the.
We'll admit it, but what about these 2 IAs? We have 2 IAs.
Lordship, I am appealing for respondent 1 to 4. Lordship, my submission is that the case was filed in the year 2022 before the Learned Tribunal, 2014, and judgment was delivered in the year 2022, 8 years. Case was pending. They have got sufficient opportunity to adduce evidence.
Why there are 3 IAs? Is there any IA for condonation?
Yes, let's say, one is, let's say, delay in filing the appeal, let's say, that was condoned. Delay was condoned. One is the stay petition, let's say.
Delay was condoned?
Yes, yes.
Delay was
And
condoned.
another IA is, let's say, order 41, rule 27 for adducing additional evidence.
Lordship, my submission is that the trial was for 8 years. And they have got sufficient opportunity to adduce evidence to show that it is liability only policy. They have not exhibited the same, produced the same. And now at this stage, they may not be permitted to take such ground. What prevented them to produce the policy copy during the trial period?
Okay, at this stage, appeal may be admitted.
We'll admit it.
No,
Record
50%,
for
50% may be.
whether the
placed.
policy was on the record or not,
Lordship.
that up to a certain lordship.
Have you applied for?
They
No,
may,
stay.
they may file objection regarding my.
Stay petition is there. I may be allowed to withdraw 50% of the order.
when there was no liability in this case, Lordship, when the
They
question.
have got sufficient opportunity to adduce evidence to prove that it's a liability policy only. Long 8 years it was running. And they have not produced the same. Now at this stage, they are,
As per their evidence also, the vehicle insured with us was not an offending vehicle. As per their evidence also. But the liability was fastened upon the insurer of the.
How many insurance companies are supposed to pay the compensation?
There were 3 vehicles involved in the accident. So in other analogous case, Lordship, liability was fastened upon the insurer of other 2 vehicles. Lordship, kindly see that.
So they have not.
no.
The other 2 insurers have not appealed.
Lordship, kindly see
No,
the page number in analogous MSC case number, Lordship, 15 of 2024, which judgment started from page number 30. Page number 30, Lordship, in my memo I will.
This is the analogous case.
Yeah, analogous case, Lordship. In that case, Lordship, will find in a page number 46. In the result, the claim petition allowed on contest an amount of 3,62,000 only to the paid by the claimant by the opposite party number 7 Solomon method general insurance from an insurer of the opening track. Track bearing registration number AS 10-616 and an amount of which 1,81,000 will also be paid by the claimant by the opposite party 3 National Insurance Company Limited. So in the analogous case, Lordship, liability was fastened upon the other 2 insurer of the vehicle. But the instant case, the liability was fastened upon the.
40% to the insurer, the vehicle.
But in the
involved.
instance also, party was made,
40%.
the other 2 insurer was made party in this case also.
How many, this is an accident between bus,
No, Lordship.
truck? 3 vehicles? What
3
are the
vehicles,
vehicles?
one is the motorcycle, one is the truck, and another is the, Lordship,
Indica car.
Indica. Tata Indica. So, Lordship, at this stage, appeal may be admitted, record may be called from Lordship.
Lordship, my prayer is that at least 50% may be deposited and released at this stage.
Lordship, we can deposit, but that cannot be withdrawn.
No, Lordship, their plea is that the insurance policy is liability only policy. They have not adduced any evidence
Lordship,
to
kindly see
prove
that-
the same. Long
Lordship-
8 years, the trial was going on. And now at this stage, they want to produce the same. No reason has been assigned why they have not produced the same.
That is why I file a petition, Lordship, order 41.
Petition will not be allowed.
See, what I have decided is, there's a petition for stay, I'll stay. You deposit the money, then
Release the
50%
same.
will be withdrawn. Meanwhile, I'll allow the other.
That cannot be withdrawn, Lordship.
Maybe allowed to withdraw.
Meanwhile, I'll allow the other petition by you to adduce evidence relating to the insurance policy.
Lordship.
You
We'll
adduce
deposit
the
50 we'll deposit 50% of the awarded amount.
Deposit and release. But
Let them file petition.
claimants are,
No, if you adduce the evidence, if they withdraw the amount, if the evidence is in your favor, they will have to return the amount.
Lordship.
They will have to return the
They
amount.
are by furnishing the bond, Lordship.
They'll
They-
finish a ball.
Lordship.
So all the
Lordship.
petitions are. disposed of.
And all the memo of appeal as well as other petition may be furnished to me.
Copies, yes, okay. So we'll start with the petition with stay. Where is the petition with stay? Which number? IA number?
Number, let's see.
Petition.
So many IAs, we have lot many IAs.
2814, Lordship.
Huh?
2815.
2815, okay.
2814, 2015.
2814. 459, 2814. It is 2815 here.
2815.
14. Yeah, that's 7. Wait. 2814.
Oh, 2814. No, this is for evidence.
Then 2815.
2815.
Yes. This is for stay. 2815 লিখিবা, huh? Heard learned counsel, Mr. L. Sharma,
KK Bhatta.
Mr. KK Bhatta for the applicant stroke appellant who has preferred an appeal against the judgment and order dated 18/7/2022 passed by the learned member MSCT Hailakandi in connection with MSC case number 16/2014. Post of heard learned counsel Mr.
M. Talukdar.
M. Talukdar for the
Respondent number 1, 2, 3, and 4.
respondent number
1, 2, 3, and 4.
1, 2, 3, and 4, comma, claimants of the original MSC case number 16/2014. I have considered the submissions at the bar. The appellant is aggrieved by the order as 3 vehicles are involved in the accident, and it is submitted that although liability has been cast upon the appellant to pay the compensation, judgment and award likiba the beginning order to pay the compensation to the claimants, yet in an analogous case arising out of the same cause of action, no liability was cast upon the appellant. Full stop. It appears that the operation of the impugned judgment and order may be stayed. Full stop. Thereby, the operation of the impugned judgment and order dated
18/7/2020.
18/7/2022 passed in MSC case number 16/2014 is stayed until further orders, subject to the condition that the applicant deposits 50% of the 50% of the compensation within 4 weeks from today before the registry of this court. You file an application for withdrawal
Release it right now.
in this order.
Lordship.
They filed the application also.
You file.
Right now,
application.
maybe release, Lordship.
You file an application. It will be better.
The
Because
claimants are suffering, Lordship. Old age
They will file the
parents,
application.
minors, son is there.
the hard learned counsel for the claimants who has submitted that the claimant is an old and claimant number 1. Which one is old and ailing?
1 and 2 parents,
Claimant number 1 and 2 are old and ailing
3
persons.
3 wife, 4
And have
minor
submitted
son.
for withdrawal of the withdrawal of the amount of compensation deposited by the amount of compensation to be deposited by the insurer. Full stop. Considering the submissions at the bar, comma, the claimants are allowed to withdraw the 50% of the compensation on their execution of a bond to be for verification by the registry of this court. In terms of the above observation, this application stands disposed of. Heard Mr. এইটো আগতে এখেতৰ নামে লিখি দিবা KL Sharma no KK Bhatta learned counsel for the appellate main case to MSc and learned counsel Mr. RL Talukdar M Talukdar for the claimants stroke respondent number 1 to 4 admit call for the trial court records issue notice to the respondent number 5
No, that's okay.
5 to 11. 5 to 11.
5 to 11 returnable within 4 weeks call for trial court record likhila na
And another IL also.
yes I'll allow this evidence
Evidence. Well, it may be hard, Lordship.
okay
It may
then.
be hard. I have not received the copy.
Appellant to furnish copies of all the applications and the appeal memo to the respondents. We'll allow you. If it comes up before me, of course.
My lordship, may I mention item number 2, which was taken up in the morning, transfer petition number 58 of 2025. My lordship was pleased to issue notice returnable within 4 weeks. My lordship, I had also mentioned a prayer about the stay of the proceedings in the Udalguri court. If my lordship may include in the order about the stay part.
The stay I'll have to hear. I have to hear, we'll take up in the afternoon.
Okay,
Or
my lord.
relating to stay, I'll have to hear.
Okay.
And I have to go thoroughly through the petition and the documents.
Okay, my lordship.
You want to submit, resubmit?
Yes, yes, my lordship.
But I have already passed an order, I will take up later. I have already passed an order.
May I lordship?
I won't retract now.
Okay, my lordship, may I
On
find
on 8, KT,
4 weeks.
We can prepone the date.
Actually, my lordship, the next date in the trial court was in 16 September.
The date to High Court, we can prepone the date.
My lordship. My lordship.
Then order. Revenue authorities are directed to assess the cultivation and rearing of fishes in a pond according to the rates under which they have estimated the compensation for the acquisition of total 1 bigha, 2 gata 15 lesses of land as per the letter number RLA 115 so and so dated 17/2/2006. Okay.
Item number 47, for pronouncement of judgment and order.
This order is set aside. Order by the magistrate is set aside.
Item number 45 for hearing, updated item.
My lord, I am extremely sorry, my lord, today. Yes, I earlier also I took time.
You're not well, I think.
Yes, my lord,
You
today
could
my lord,
come.
some difficulty. My lordship. Because my lord, I'm also engaged in some other courts also, my lord,
Oh.
today.
So when should I take it up?
Any date as per the convenience of your lordship. Any date.
Yes.
Not possible, lordship. How
Not
it is,
possible.
how it is possible, lordship?
Too many adjournments.
Yes, lordship.
Yes.
9 times.
9 times.
9 times.
But I'll have to hear the other side.
Yes, sir.
This is not an easy appeal. And
No, what is the problem? Have to file an reason.
I cannot dispose it of. I'll have to hear the other side.
Yes.
It's an NDPS case.
But lordship, this is not the way, lordship.
True.
In the eye of law, lordship.
Too many adjournments have been taken. So this will be the final.
Yes, my lord, your lordship.
When this will be according to your convenience.
Yes. Your lordship it on 16th of September then.
That will be, I think, too late.
Every time we come and wait all the day and
Then, my lord, any date as per the convenience of your lordship.
9 September?
Yes.
9 September.
2 days first.
Yes, 1 week.
After
1 week.
no, lordship.
No,
After 2,
September
3 days.
9th.
After 2, 3 days, please fix it.
9 September, my lord, your lordship has
On
already
that day,
fixed.
the another one he promised me.
No,
that
he is,
No, no.
give me
my
the-
lord, he is lucky one that 24 matter, my lord, already. Matter
No,
is,
you see, this is a matter of 24. We have updated it according to your convenience
sir.
all the time, and we have given
yes,
you
yes, ma'am.
dates according to you all the time.
Yes, ma'am.
And it's true they have taken adjournments, but we'll have to hear the other side. This is a NDPS matter. It's no joke.
On 9th, my lord, at 2.
On 9th.
It is not possible.
No, no, he fixed.
Sorry, 6.
Obliged.
Learned additional PP, Mr. P. Bothalu has prayed for adjournment The learned counsel for the appellant has raised serious objections stating that.
Lordship,
Mm.
the IA,
Mm.
that one IA, if kindly give an order, interim order, I can take 5 months, no problem, Lordship.
No, he's at all time, he's my lord interrupting your lordship has already my lord fixed the matter.
Yes, I am waiting 1 year now for this judgment.
You are lucky one that your matter of 24 matter fixed on in the year 2020. So till
I
nine,
will tell you, see,
your lordship may kindly fix
every
it
day
on
you are
9.
objecting this one.
I never objected, my lord.
On 9th, I'll take up, otherwise if he doesn't submit, then I'll take up the I on 9th.
Yes, ma'am.
Has raised serious objections stating that several originals have been procured by the prosecution. Full stop. The appellant has been prejudiced as this is a case of clear acquittal and he's behind bars. Full stop. Considering all aspects, matter is fixed for hearing positively on 9th September.
Yes.
Okay, I'll take up the IA if he doesn't
Yes.
But
submit.
mention the line, if not possible, I will be.
Okay. Failing which the petitioner's interim application may be taken up for consideration.
Oh, bless.
Yes.
Okay.
Item 17 for admission.
Please, your lordship.
Mm.
This is an appeal under section 173 my lord, of MV Act for enhancement my lord. Against this judgment order dated 9/7/2025.
Will
By
issue
the
notice?
line-
Will issue notice? Learned counsel, Mr. D. Das.
BJ Talukdar. BJ Talukdar.
BJ Talukdar is present on behalf of learned counsel for the appellant, Mr. D. Das.
Yes, my lord. My name is also there.
Okay, learned counsel, Mr. BJ Talukdar is present for the appellant. Full stop. Steps to be taken to issue notice to the respondent, returnable within 4 weeks, call for the trial court records, admit,
Yes, ma'am.
list accordingly.
Much of this one.
Item number 18.
May please, your lordship, against the judgment and order of the tribunal and city tribunal.
Claim.
The appeal. In tribunal, file a petition under section 164, but the judgment under section 166. This is the enhancement of error.
Enhancement. Learned counsel,
one-
Mr.
N. Ahmed.
N. Ahmed is present for the appellant. Issue notice to the respondent to be returnable within 4 weeks, call for the trial court records, appeal is admitted, list accordingly.
Item 19.
Yep.
Date hearing.
Well, it's a anticipatory bail, my lord. I'm on interim, my lord, and I appeared. my lord. PPS and account.
PP has a CD, I think PP is not here. A bail hearing, I think CD has to be.
CD,
Or I think CD is already here.
here, CD is here, my lord. Last occasion, my lord, they took time, my lord.
Okay,
Or your lordship will fix another date.
another day. But then the CD will be pending,
Yes, my lord.
so we'll hear you out.
If your lordship sees the order dated 27/05/25, my lord.
Mm.
Lordship's order. I said.
Okay.
He's a juvenile, my lord,
Mhm.
and that order, my lord, that Dasarath Roy versus State of Assam, it's there in the file. Yes. Your lordship had mentioned, my lord, paragraph 6.
Mhm.
My instruction is that, my lord, after getting this anticipatory bail, my lord, he appeared before the IO.
There are 3 bail hearings.
Yes.
Okay, whatever he submits, I'll pass an order on his submission.
He'll be there, my lord.
submission delay হৈ যাব।
Item 20. This is same affair case, my lord. Similar matter, my lord.
Same, out of the
Same-
same cause of action.
Same cause of action, similar.
You have to say
Same
for-
affair, same affair case. Only updated case that was called for, my lord.
What is your submission?
My lord,
Person was, he was a juvenile, he is on interim bail, but you are not a juvenile.
I am not interim, but my lord, I am only agreement holder. I have no relation with this case, my lord. All the accused are released on bail, my lord. I am absolutely innocent. Only, my lord, I am the owner of the agreement holder. Original owner is the, my lord, one Mofidul Islam, registered owner, and driver Abdul Mia, and already, my lord, released all the Abdul Mia, Kabir Ali, etc. Other accused are released on bail. So, my lord, he will face the trial, my lord, if he released on bail, my lord, and cooperate with the investigation agency, my lord.
Let the PP come and, according to his submission, after taking into consideration your submission,
Match.
then I'll pass an order.
Deep oblige. 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 Oblige.
Oh. Oh. These two, they have submitted on item 19 and 20.
Well, kindly for the time being, my lord, Pranjit Locker is, my lord, suppose he is in Kotamba, he is coming, my lord.
Okay.
After some time.
নে এইটোতো হৈ গ'ল তো মই হেৰি লিখি থোৱা আছে নোট এটা আছে মই সোমাই এইটো
After some time.
Item 22. Wait, please, Lord. My lord, case is regarding specific performance of contract. So, my lord, in the both the courts below, my lord, dismissed my suit. My lord, my first submission before your lordship that actually the agreement, who was written the agreement for sale, he was examined as PW2. He said that yes, agreement was written by me and the landowner executed this agreement for sale before me. And another PW 3 and 4, my lord, they are the attesting witness of the agreement for sale.
PW 3 and 4.
3 and 4. They were examined that they said that yes, at the time of execution of agreement for sale, we were present, and these are our signatures. But the court below, my lord, take other views, my lord. So that is the substantial question before your lordship, whether this evidence of PW2, PW1 is the plaintiff, my lord. I am not going to PW1, but PW2, 3 and 4. One is scribe, another two attesting witness. Those evidences are not scrutinized properly, misread the evidences. So, my lord, at this stage, my lord, my appeal may be admitted. Notice may go.
What is the agreement?
My lord, agreement, my lord.
Where is the copy of the agreement?
Agreement I am giving, my lord. Agreement, my lord. Just one. Agreement, my lord, yeah, along with the, your lordship will turn to is 79 onwards, my lord. 79 onwards in particular.
Where is the copy of the plaint?
My lord, plain, copy of the plaint, my lord. Your lordship. Page 34 to 85. Agreement as page 79 onwards, my lord, and plaint is 34 to 85.
Page 34 to 85.
34 to 85.
But the agreement is 79. I'm asking for a copy of the plaint.
My lord, copy of the plaint, my lord, it is including the annexures, my lord, it is pages. From 34 it is starts, my lord. Thirty-four, my lord, annexer 2. PS number 70 of 2019. Page 34. My lord, 34 to 48 is the prayer. 48 is the prayer. Decree of specific performance of contract. 48 is the prayer. And plaint start from 34.
Where is the schedule of the land?
My lord.
Schedule of the land?
Schedule of the land, my lord. At page 50, my lord. Schedule A.
Page 50.
50.
Hmm.
A plot of land measuring 1 katha out of 4 bigha 10 lashes.
Okay, I'll pass an order later. I'll pass an order later. I'll read the judgments and then I'll pass an order.
My lord.
I'll pass an order later.
My lord.
Only the operative part of the judgments I'll read and I'll pass the order later. Later.
And your lordship, first thing is this, if your lordship admitted my appeal, second appeal on substantial question of law, I have formulated some substantial question of law that is at page 5.
I've seen it.
Yes, madam.
I'll pass an
And
order. later.
next thing is this, my lord, there is an IA also, IA civil. Just, my lord, it is an
For state?
under order 39 rule 1 and 2 to maintain status quo over the land. It should not be disposed of. That is the thing. If your lordship interfere immediately, that is one thing. And if your lordship is pleased that let notice go and thereafter I will consider. In that case, my lord, in my IA, notice may go. Yes. Much obliged.
পাছত কম নামবিলাক কম No, no, time like it.
Howla Jilash.
Lordship, this case was in fact disposed of. We deposited the amount and it was.
And we have
finally-
already withdrawn for respondent number 1 and 2, Lordship.
Lordship will look at office note dated 28/8/25. The registry has listed the case, Lordship. Office note 28/8/25. One of the respondent. যাতে ভাবিছো আমাকে থাকিবি পইচাটো তো সিহঁতে নিয়াৰ কথা আমাৰ কাৰণে কি আছে
Yes, yes.
Lordship, that office note shows that for Gangaben Hansraj Shah, for her 5,14,283 is in the registry. Lordship, we do not have anything to do. She has to come and collect it from the registry. And
I have
therefore, they have
I have
already
withdrawn.
collected their amount. They have already withdrawn.
So we can dispose it of.
There is actually why
It is
registry
already
said there is no question of disposing, already disposed. Lordship. Registry has given a note that the amount is there. Fine, she has to come and take that amount.
She
Lordship.
has already taken.
No.
I'm
he-
paying for 1 and 2, Lordship. For the
Okay.
wife and son, I'm appearing. Mother is there, respondent number 3.
This is the mother of the deceased, Lordship.
So you
Gangaben-
come and take.
Lordship, I don't have any connection with respondent number 3. আমি dispose of file only.
দুনিয়া ভৰৰ পইচা পৰি আছে এইটো কেছত কিহৰ কাৰণে ইমান হেৰি লাগিছে
তাত already order দিছে 1 and 2.
তেওঁৰ কাৰণে এইটো হেৰি কৰি দিয়া হৈছে যে that much she will get order দিয়া আছে তো judgment-তে আছে
আপোনাৰ judgment-ত আছে এইটো judgment 1 and 2 কৈছে
I think you don't have to pass any order here.
That's what Lordship, but I leave it to Lordship because there is nothing to adjudicate on this. Like, that amount is there, it is for her. Whenever she comes, she can withdraw that.
Yes.
That is
And registry will issue a notice.
Maximum registry can issue a notice, Lordship.
You থাককচোন অলপ দেৰি এলোক আহিছে বাৰু থাকক and what about the other one?
No, disposed of, Lordship.
Already,
Both
both the
the
matters.
cases are
Okay.
disposed of and we have deposited. Claimant number 1 and 2 has taken their money. Only for 3 that amount is there, which he has to come and collect. So, if registry wants, registry can.
কাবাক মাতি লম section of it.
Lordship, we can leave.
Style of yes.
Highly obliged, Lordship.
Style of মাতি লম section.
My lord, this review petition was originally dismissed by this honorable court by order dated 5/10/2023, which will be there in your lordship's file. 5/10/2023, this review petition was dismissed. Then we went to the Supreme Court, the petitioner. Supreme Court set aside the judgment and remanded it for your lordship to decide affairs. There are some directions given. If the Supreme Court order is flag B in your lordships. Flag B.
Yes.
Your lordship will see
Yes,
the
please.
arising out of, I'm leaving itself in below, arising out of impugned final judgment and order dated 22/8/2018 in RSS 73 of 2013. 510/2003 in review petition 97 of 2018. This is 97 of 2018. Your lordship will see the order. Therefore, the matter is required to be heard.
Okay. Yes.
Required to be heard. And then as per the order of the Supreme Court, my lord, the lordships may have to consider it on merit because it's with law. And if your lordship has noticed that his lordship in Supreme Court has said that the scope of review is much wider.
Yes.
So therefore, this is required to be heard. And then the lordship so desires, I can begin the hearing.
We'll list it for admission or
Uh,
we'll.
Well, it's a review petition, your lordship, straightway fixed for a hearing, or it can take up at this
We can fix
stage.
it for hearing or we can take up today. I think he is not prepared, I think.
No, my lord, we can do it. We are prepared with it.
Prepared.
But if my senior other side wants to take time, it's no issue.
No, I don't want to take.
No, whatever.
I don't know.
If the
It's
lordship
up to the
feels
court.
to fix another date for hearing, no issue. It's up to your lordship, my lord.
But if your lordship decides to fix it on it should be fixed on a hearing day.
Yeah, we'll fix it on hearing day.
My lord.
आपको वेकेशन कराएंगे आपको वेकेशन कराएंगे
जाएगा लेकिन
ये तो बोलो
16 will be all right.
It will be fixed directly for hearing. It was already heard and decided.
That's
so it will be
right, my
fixed
lord.
For hearing.
Well,
Learned Senior Counsel, Mr. D.K. Mishra, assisted by Learned Counsel, Ms.
Prana Ahmad.
Is present for the petitioner. This is a petition, no? Yes, petitioner and Learned Counsel, Mr. J. A. Sahiwala, no?
My lord.
A. Sahiwala is present for the respondent. This matter has been remanded back. This matter has been remanded back, no? From the honorable.
Yes, from the Supreme Court. It was
Remanded back.
By setting aside
By setting aside.
the order dated 5/10/2023.
The order dated 5/10/2023 passed by this court in connection with.
This present review.
In connection with this case. 5/10/2023. 5/10/2023 passed by this court. List this matter for hearing on. Is it okay? 16th October.
My lord.
दिवाली का
Hey, it's future lordship.
It's up to you.
Yes, my
16th
lord.
October.
वो तो दिवाली के पहले पड़ेगा दिक्कत हो जाएगा
My lord.
Any other date?
Any other date other after Diwali, my lord?
After Diwali.
Because otherwise it will come up
23rd.
30 October?
my lord.
30 October.
Because great to know.
Item 19. Item 19.
19 and 20 same lordship.
Right, yes, I know. Already heard. 19 and 20 already heard.
Only my part left.
Yes, yes.
Here, Lordship, in item number 19, Lordship. Both here, 19 is the son and 20 is the father. And the allegation is that, Lordship, stealing of Lordship 600 numbers of cartoon of IMF, Lordship. So, Lordship, here, as per CD, Lordship, I have gone through the CD, Lordship, and as per CD, Lordship, both these persons are involved. Here, Lordship, if you go by the regarding the son, Lordship, that is Lordship 19, Sabadul Islam. He is the son of the main accused, Lordship. And what he has done, Lordship, as per the instruction of his father, he brought one person as a driver and stated and informed the owner of the transport company that, Lordship, he is the son of the driver. He is the son of the driver because the driver did not come. He is suffering from fever. He will pick up the vehicle at the mid of the way. So he is the son. So he introduced him as a driver. Thereafter, he took away the vehicle by carrying all the articles in his vehicle, and took away he has driven the vehicle, and he went to a point. Thereafter, he left it, handed over the entire truck and material to his father. And as per the instruction of his father, he whenever some phone calls from the transport company comes, that where you have how up to how where you have reached, he is he was trying to misguide. He was misguiding. We have reached this place. We have reached this place. He was misguiding all this. And subsequently, when father reached a specific point, he hasn't mentioned. He doesn't. Subsequently, after one day, his father asked him to stop to switch off his mobile, and he switched off his mobile. He switched off his mobile thereafter. So, Rossi, he is fully aware what he was done, what he was doing.
You see, I have granted interim bail to the son.
Yes. Because Rossi, but he yes, giving interim protection to a person, that is not that.
But you see, he is a minor, and then look at the environment he has been brought up in. Father is asking him to do all these things. So I think father maybe can be rejected, but minor, let him.
But minor lordship, that when the act is we have to see the acts of the minor lordship. He was not the minor. He was when he himself has driven the vehicle. A minor cannot drive the vehicle, but as per CD, he was driving the vehicle, and he was introducing someone as a driver's son. So he was a
the behest of his father.
No, Lordship, at the behest of his father's Lordship, but Lordship, the act, Lordship, he was fully cooperating with his cooperating his father, Lordship. It is not like the Lordship, he was not cooperating, but when he was fully cooperating with his father, and now also he has not given any information regarding his father, regarding his material, and anything else, Lordship.
It's okay, he's not entitled to bail, but son. Has his statement been recorded in the
statement recorded? He himself has stated everything. It is. Yes. Juvenility claim, that if they are claiming juvenility, then bail and AB itself will not applicable.
Bail, I think there's a division bench order here. In juvenile case.
So in that case, Lordship, we have to see the independent it as a independently, Lordship, not as a juvenility, Lordship. We cannot determine the case as he is a juvenile. So then AB, both will not come, Lordship. We have to see it independently without going to his age, Lordship. Otherwise, in every cases, he will get sympathy.
No, it's okay in murder cases, and I'm not taking up these matters, but say murder case or POSCO Act or this, but this
Here also
father is asking him to operate under his instructions, and then he will learn whatever he's taught by his parents. What is his age? Age?
He's 17 years old.
17 years.
It is not, he is not for 13, 14, 17 years is nowadays quite. If someone comes regarding in case of POXO case, he says he's 17, everyone will say then, from that part of
He's tried as an adult.
adult person. The argument from the other side will be now he is 17, so he is adult, and she it is 18 years, like it would be sufficient. So when
আছে? লিখে। But learned counsel Mr. N.J. Dutta for the petitioner. A order dated 27/5/2025. Paragraph 1. Paragraph 2. Now to Diziba. Additional PP. PS Lockout. Paragraph 2. Paragraph 3. Now paragraph 3 now. The learned additional PP has raised serious objections stating that there are incriminating materials in the case diary against the petitioner. Full stop. The petitioner is almost at the verge of attaining majority, as he is for more than as he is more than 17 years old. He was more than 17 years old at the time of the incident. It is further submitted that the petitioner has admitted that on the petitioner admitted that he has acted on the behest of his father. Full stop. I have also scrutinized the case diary. Full stop. It is submitted on behalf of the petitioner. That a truck bearing registration number A01RC 7886 loaded with 600 cases of nuts disappeared while proceeding from Goripur to Sansari. Full stop. The phone number of the driver was found to be switched off when the informant made several attempts to contact the driver. I have considered the submissions at the bar. I have considered the submissions at the bar. Full stop. The petitioner is the son of the owner of the vehicle. He has appeared before the IO and the statement has been recorded. Investigation has progressed substantially. Full stop. The petitioner has pledged to cooperate with the remaining part of the investigation. Full stop. It appears that custodial interrogation may not be required. Thereby, the interim order dated 27/5/2025 is made absolute under the same terms and conditions. Send back the CD. Itu তুমি ললো। Item 20. Itu wicked. Heard Mr. Itu. এইটো ৰেকৰ্ডৰ লগত দি দিবা দেই টাইপ কৰি পেলাই Heard Mr. B. Islam, learned counsel for the petitioner. Pavan Ali, who has filed this application under section 482 of the BNWS 2023 with prayer for pre-arrest bail as is apprehending arrest in connection with so-and-so PS case under so-and-so sections. Had Mr. P.S. Local Learned Additional PP Assam, who stopped the Learned Additional PP has raised serious objections stating that they are incriminating materials in the case they are against the petitioner to stop the petitioner in League LEAUGE with his son committed theft of 600
IMFL cartoons.
cartoons, no? 600 cartoons of IMFL, which is a serious offense. Has raised serious heavy submission DS, no? Has raised serious objection cartoons of IMFL cases of IMFL, no? The truck bearing registration number A01RC 8886 was loaded for MSJC Business Private Limited, Silchar, from Parnod PRNOD Ricard India Limited. No, and was proceeding here from no. Private Limited Silchar and was proceeding was proceeding to Likidia. Proceeding to MSJC Business was proceeding to MSJC Business Private Limited Silchar from Parnot Ricard India Limited, Goripur. Who stop? The vehicle, however, did not reach the destination at Silchar, and the driver's phone was found to be switched off. Full stop. It is submitted by the learned additional PP that the father and son duo have instructed the driver to switch off the mobile phone, and after switching off the mobile phone, the 600 cases of IMFL have been taken away by the accused. Full stop. It is submitted on behalf of the petitioner that he is only an agreement holder. Full stop. The petitioner has also prayed for bail on the ground of parity. Full stop. It is submitted that all the accused are on bail. Full stop. The petitioner is innocent. full stop. The petitioner is willing to cooperate with the trial. I have also scrutinized the case diary. There are incriminating materials in the case diary against the petitioner. Full stop. At this juncture, it appears that investigation may be adversely affected if the petitioner is insulated by an order of pre-arrest bail. Full stop. Considering all aspects, petition, considering the allegations and the gravity of the offense, petition with prayer for pre-arrest bail is rejected at this stage of investigations and with the city. Item 21.
This is the second bail application, my lord. And first
You have the
application-
CD?
That's it.
FIR page 12, my lord. FIR is the page 12, my lord.
Page?
Page 12. 12. Thereafter, my lord, the petitioner along with three others, my lord, filed bail application, my lord. And on interim date, the petitioner granted bail, my lord.
You have granted bail?
Thereafter, my lord, after receiving the CD, my lord, bail was rejected.
Or
my lord.
rejected?
And during the interim, my lord, the petitioner already appeared before the IO, my lord. All the statements has been recorded, my lord. And now, my lord, registered on 14/1. And now, my lord,
You have any new grounds?
grounds, my lord, I stated in like paragraph 13. Page 9. More than six months already gone, my lord. But all the statement of the accused already recorded, my lord.
I rejected the bail.
My lord. No, my lord, rejected, my lord, but interim was granted, my lord, page 21, my lord.
Okay, I have grant,
The
okay.
CD rejected, my lord. Page 23, my lord.
Others have been released on bail, only
Bail.
these petitioners, okay. What do you have against him?
Person, this is the same as it is as earlier, lordship.
Nothing new.
Nothing.
What are the injuries sustained by the victim?
Some fractures are there.
Fractures? On which part of his body?
Yes, my lord.
Face, lordship. This is
Face. Face, fracture on face.
Already, no further interrogation is required.
Where is the ground, new ground?
New ground, my lord, paragraph 13, page 9, my lord. And he is also the, my lord, the government employee, my lord. He going to retire on December, my lord, 2025, my lord.
lordship can dispose of this because lordship aged person and investigation is sufficiently progressed. Statements are so many.
Complete, almost complete.
Almost sufficiently progressed.
It page. Our learned counsel, Mr. K.R. Padgiri, for the petitioner Tulon Doctor, who has filed this application under section 482 of the BNWS 2023 with prayer for pre-arrest bail as he is apprehending arrest in connection with so-and-so PS case under so-and-so sections. The petitioner has filed this subsequent bail application on the ground that investigation has progressed and also on the ground that the co-accused have been enlarged on bail. Full stop. The learned additional PP, Mr. P.S. Locker has submitted that they are incriminating materials in the case diary against the petitioner. Full stop. I have also scrutinized the case diary. Indeed, there are incriminating materials in the case diary against the petitioner. The allegation against the petitioner is that he assaulted the victim, causing grave injuries on his face. Full stop. I have considered the progress of investigation. Full stop. The petitioner, I have also considered the submission to the petitioner is willing to cooperate with the remaining part of the investigation. Full stop. I have also considered the submission to the petitioner is a government employee and he is indeed not a flight risk. Full stop. Investigation has progressed substantially. It appears that bail may be granted to the petitioner considering all aspects. Petition is allowed. In the event of this arrest, the petitioner shall be enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the arresting authority under the condition that the petitioner shall appear before the higher within 1 week and cooperate with the investigation. Number 2, the petitioner shall refrain from such activities with which he is alleged. Number 3, the petitioner shall not exercise threats to the witnesses or hamper with the evidence. Number 4, and the petitioner shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, bail order shall stand automatically cancelled. Send back the CD.
Obliging.
No, because it is not so much serious than like the earlier one.
Earlier is a minor actually, and then we have to see the environment also under which these minors are brought up actually. They may turn out to be good citizens also if they are not brought up in such environments.
Also, there are 4 appealants.
Hmm.
Appeal has been filed against order passed by the First Appellate Court.
Order, no?
First Appellate Court.
Yes.
Let's say appeal has been admitted, and thereafter, let's say the 2 appellant has died. Uday Sharma and Ghanesham Sharma had expired.
Hmm.
Earlier advocate appearing with this case
Hmm.
has not informed regarding there was no contact with the earlier advocate.
Hmm.
Therefore, new set of advocate has been engaged, and new set of advocate came to know that Uday Sharma and the Ghanesham Sharma has expired. Immediately, petition has been filed for substitution of legal heir of Ghanesham Sharma and Uday Sharma. Application for substitution, cancellation of abatement, and let's say the petition for condonation of delay. In the petition for condonation of delay, respondent has filed objection, stating that the ground for engaging new set of advocate was not mentioned in the application for condonation of delay. Lordship can kindly see their affidavit.
IA number?
IA number 1524. Affidavit filed by Son Malakot that was received on 30/10/2019. Son Malakot.
Affidavit.
Lordship. An affidavit in opposition file respondent number 1, 2, and 3, shown by Son Malakot.
ওলাই গৈছে কাগজবোৰ নহয় ওলাই আছে
In base case number 1521 of 2019.
1521
Yes, also.
এইটো নহয় এইটো 1527 1521
Lordship, what the affidavit?
Additional affidavit.
No. Affidavit by respondent number 1, 2, and 3, shown by Son Malak.
Dated?
Page 12.
Was filed on?
Filed on 30/10/2019.
13/10?
30/10/2019, Your Lordship.
30/10/2019.
Page 12. Running page 12. Running page 12.
Yes,
Lordship, Son Malakar, Lordship got it.
yes.
Now, Lordship can kindly see para 5. Para 5. With regard to statements made in paragraph number 3, 4, 5, 6 of the instant interlocutory application, deponent beg to submit that the statements made are not at all true. The fact engaging in new set of advocate cannot be denied, but purpose behind engaging new set of advocate is not explained in the instant interlocutory application. Lordship got it? We have immediately filed an application, additional affidavit stating the reasons for engaging in new set of advocate. Lordship will find our affidavit
When days delay?
additional Lordship 556 days delay.
500?
Lordship 556 delay. Lordship is aware there are 4 appellant. One of the appellant can prefer an appeal. 4 appellant has joined to file appeal, and 2 appellant has died. Without that appellant also appeal will survive. But as a prudent advocate, we have filed this application for substitution with a petition for continuation of delay. Purpose, what is the purpose? Purpose is our appeal. They will not get any benefit by dismissing the petition or by allowing the petition. No benefit will be given to us. We as a regular process, we have filed this application for substitution. And 2 appellant is already there. 2 appellant died. New set of advocate is engaged because earlier set of advocate has not made any contact with my client. That is why they have been compelled to engage new set of advocate. And new set of advocate, after going to the instruction, came to a finding that earlier advocate was not informed regarding date of Uday Sharma and others. Lordship, can you see additional affidavit in support of the haberments? Para 3, Lordship, page 16. Running page.
Affidavit. Filed by whom?
Filed by us, Lordship. Additional affidavit in support of our application.
Page, which page?
Page 16, running page 16. Why they are filing objection one after another, I do not understand. Also. Additional affidavit.
No, it's not at page 16.
Running page 3 from page 14. Also.
Additional affidavit filed by?
Filed by the appellate.
Karuna Sharma.
Yes,
Lordship.
Lordship.
I have got it. On 5th August
Lordship.
2025.
Lordship.
Okay.
Para 3, Lordship. Present deponent along with the other appellant engaged advocate, namely R.S. Suhan, for filing an appeal before the Honorable High Court, being aggrieved and dissatisfied with the judgment and decree dated 33/2012 passed by learned civil judge Nolbury in title appeal number 05 of 2011, allowing the appeal by setting aside the judgment and decree dated 28/7/2010. I am the plaintiff, Lordship. My suit was decreed. Against that, they have preferred appeal. Appeal was allowed. That against that order, we have preferred the RSA. RSA, there is the order. RSA has been already admitted. During pendency of the appeal, the Uday Sharma and Ghanshyam Sharma expired. So we have to file an application. Reason behind is learned civil judge Nolbury title appeal number allowing the appeal by setting aside a judgment and decree dated 28/7/2010 passed by learned Munshi number 2 Nolbury in title suit number 16 of 2005. Said appeal has been filed on 23/7/2012 along with IA. Said appeal was listed for admission hearing as same was admitted on 9/6/2014. Thereafter, appeal has been listed on different dates regarding service of notice. Subsequently, on 30/10/2019, said appeal was transferred to the Lojima Court regarding incomplete service of notice. Present deponent engaged as R.S. Suhan as an advocate. On verification, deponent found that some other advocates are appearing in the case. Nothing has been communicated with the deponent along with the other appellant regarding development of the case. Thus, finding no alternative, deponent along with other appellant engaged and appointed R. Sharma to defend the appeal. This R. Sharma has appeared, Lordship, my friend. R. Sharma has appeared, was engaged by the deponent to see their interest. As no communication was received regarding development of RSA 100 of 2014 from the earlier advocate. Consequently, deponent along with other appellant engaged advocate, namely R. Sharma, and thereafter advocate R. Sharma called the appellant to know the actual address of the respondent for service of notice. Thereafter, advocate, namely R. Sharma, came to know regarding date of appellant number 2, namely Uday Sharma on 2/11/2006, Accordingly, after knowing this fact, engaged advocate R. Sharma informed that since the appellant number 2, namely Uday Sharma, has expired, it should be substituted by legal heirs. Therefore, IA Iman has been filed for substitution along with the petition for continuation of delay and cancellation of abatement. RSA number 100 of the was
It's
not
okay,
listed.
it's okay.
That is the ground.
What they have to say, let
Lordship,
me
my
hear.
objection is that in the affidavit in objection, they have stated that in paragraph number 3 that the new set of advocates were engaged in the month of September 2018, but the appellant number 1 came in Guwahati on 7/3/2019. They took 6 months time to file the delay condonation, and your lordship, it has not been explained, and also in the additional affidavit filed by them, they have stated in paragraph page number 18, in paragraph number 3, Advocate R. Sharma filed wakalatnama on 17/9/2018. Then they have filed the delay condonation on 26/3/2019. There is a gap of 6 months. They have failed to explain that in that regard.
What is the purpose, Lordship? Appeal. Appeal is filed by 4 appellants. 2 appellants died. Appeal will automatically survive. Nothing will happen to
Yes,
them.
I see, as it's true, appeal will survive, even if the legal heirs are not substituted. The other brothers are dead, maybe they are brothers, so appeal will survive.
Your lordship may pass any order.
I can condone the delay, I think, though there is a delay, no doubt about it, I can condone the delay, I think. These are hard learned concepts. 151, I 151, hard learned concepts for the applicant. Stroke appellants who have filed this application. Under section 5 of the Limitation Act 1963 with prayer for confirmation of delay of 776 days in filing the application for certification of the legal heirs and representatives of the deceased, appellant number 2. Only appellant number 2.
Appeal number 2. Lordship, 2 separate application has been filed. 2 petition for condonation of delay has been filed for date of 2 persons. One order will cover. Lordship can substitute the name only.
Which one? The other one?
Other one is regarding date of Ghanesham Sharma. 1524.
1524.
Same thing.
1524 না এটা দিয়া দুটা কেস একেলগে লিখি দিন 1521 1524 1521 or 776 days in filing the application for substitution of the legal heirs and representatives of deceased appellant number 2 Uday Sharma in RSA number 100/2014, and further the condonation of delay of 622 days in filing application for substitution of the legal heirs of representatives of the deceased appellant number 3 Ghanesham Sharma in connection with the same RSA number 100/2014. It is submitted on behalf of the applicants stroke appellants that engaged counsel R.S. Chauhan earlier engaged counsel was R.S. Chauhan. Full stop. That the earlier engaged counsel was R.S. Chauhan. Full stop. after the appeal was listed for admission stroke hearing on 9/6/2014, several dates were also fixed for service report and issuance of notice. Full stop. Subsequently, on 30/10/2019, the appeal was transferred to the Lawazima Court regarding incomplete services of notice. Full stop. The applicant engaged R.S. Chauhan as their advocate on verification. And on verification, it was found that some other advocates were appearing in the case and nothing was communicated to the appellants along with the other appellant stroke applicants, full stop, comma, regarding the development of the case, full stop. Thus finding no alternative, comma, the applicants along with the other appellants engaged and appointed advocate R. Sharma to defend the appeal before this court, full stop. Thereafter, R. Sharma was engaged by the deponent, by the applicant, and as no communication was received regarding development of RSA number 100/2014 from NS, reply as no communication was received regarding development of RSA number 100/2014 from the earlier advocate. Subsequently, the newly engaged counsel learned regarding the death of appellant number 2, namely Uday Sharma on 2/11/2016, and the death of same date, appellant number 2 and 3. Uday Sharma and
Ghanshyam Sharma.
And Ghanshyam Sharma on 2/11/2016.
Ghanshyam Sharma died on 5/4.
Ghanshyam Sharma died on
5/4/2017, Your Lordship.
5/4/17.
Ghanshyam Sharma passed away on 5/4/2017 and
Uday Sharma died on
2/11/16.
Died on 2/11/2016. Full stop. এইটো দুটা বেলেগ একে ডেট দিছিল যে নহয় বেলেগ বেলেগ ডেট Therefore, interlocutory applications were filed for condonation of delay in cancellation of the abatement.
We have filed petition for substitution and cancellation of abatement with a petition for condonation of delay.
For substitution and cancellation of abatement. Substitution of legal heirs of the deceased and cancellation of abatement, full stop. The learned counsel, Miss
S. Sharma, on behalf of D. Chaudhary.
S. Sharma, on behalf of the learned counsel, Miss S. Sharma, who is present on behalf of learned counsel, Mr. D. Chaudhary, representing the respondents, has raised serious objections stating that that the inexplicable delay was not justified by projecting proper grounds, proper and sufficient grounds by the appellant, full stop. It is submitted that the ground relating to appointment of newly engaged counsel is not sufficient to condone the inordinate delay of 776 days as well as
621. 21 days.
622 days. So the period of 6 months in filing the application has also not been properly explained. I have considered the submissions at the bar with circumspection. It appears that there was no mala fide on the part of the applicants, full stop. It appears that the grounds reflecting the cause of delay are sufficient, full stop. Considering all aspects, I deem it appropriate to condone the delay, full stop. Thereby, the delay in filing application for substitution of legal heirs as well as for abatement for setting aside
Cancellation
the
of
abatement.
Cancellation of abatement.
Setting aside the abatement is hereby condoned in terms of the above observation. Application stands disposed of, no order as to cause.
Now, Lordship will allow the petition for substitution.
দুইটা আইও এটা কমন হেৰি অলৰেডি ডিসপোজ কৰি দিছে ডেট কিটা খালি বেলেগ বেলেগ ডেটৰ ডেট কিটা বেলেগ বেলেগ আছে
Lordship, we have to file as amended cost title, Lordship.
Oh, yes. Appellants to, your appellants, yes. Appellants stroke applicants to file amended cost title in the RSA 100/2014.
Representing the legal heir of
Representing the legal heirs of the
appellant number 2 and 3.
appellant number
2 and 3.
2 and 3. Anything else?
Lordship, you have to
This-
allow the substitution also. Both the petitions should be allowed, Lordship.
Will allow. এইটো তুমি তাত মাৰি দিব এলাউ কৰি দি দিবা প্ৰেজেন্ট কৰি দিলে তাতে পেটিশনটো দি দিলে হৈ যাব
That's
no
disposed of.
objection you said no objection none it is allow okay
So 6 petition has been disposed of. Total. 6 petition has been disposed of. Total 6 petition.
no problem হলে মোক দি দিবা
Lordship, 2 appellant died, that is why you have to file 3 separate petition. So
Yes,
all the
yes.
3 petition has been disposed.
and you see নামখিনি দি দিব লাগিব এই যোনবোৰ হেৰি লিগেল এয়াৰ্ছ আছে ন নামখিনি অৰ্ডাৰটো দি দিব
We have specifically mentioned the name of the legal heirs.
Yes, I'm just checking. This is order 22 rule 32, this will be allowed. Petition 1528, it will allow his own. নাম একে থাকিব হা This is also order 22 rule 32, this will also be allowed. Or it is key, right? Also me. Yes. 1527 allowed hobo. Are we talking? It is key. To order 22 rule. It will allow it. 1526 it will allow. হেৰি কিটা সেকশন কিটা অর্ডার কিটা ভালকে তাতে নাপালে মোক মই দেখাই দিম এইটো কোড কৰিলে ভাল হ'ব কিটা সেকশন কিটা এইটো allow হৈ যাব 1525 allow. Anything else left out? No, no?
Obliged.
Item 27.
May it please your lordship. Oh, Asha. Bad David. May it please your lordship. My lord, we filed an objection in the IA. IA civil 1259 of 1259.
We have not received any copy.
My lord, copy will be supplied, but it is not tagged with the record, my lord. It may be tagged with record and it may be listed. Today we filed.
Okay.
Copy I will supply, my lord.
Okay. Learned Counsel, Mr. A.R. Sigdar is present for applicant, stroke appellant, and Learned Counsel, Mr. M.A. Sheikh is present for the respondent number 1 and 2. And what about 3 and 4?
3 and 4, I do not know.
It is submitted that an objection has been filed,
Yes, madam.
which is not tagged along with the record. Who's of registry to place the objection on the record. Full stop. The respondent number 1 and 2 to furnish copies of the objection to the appellant. And what about 3 and 4?
But our objection is regarding opposite party number 1A and 1B.
Oh, today the respondent number 3 and 4 are not present, represented. This list this matter or for? On?
For
No, it will come up for your hearing only, but on which date?
one thing, my lord, some documents inadvertently not enclosed with the IA, but in the mailers second appeal. So may I be permitted to file an additional affidavit enclosing documents?
Okay. Learned Counsel, yes, he can file. Learned Counsel, Mr. A.R. Sigdar has submitted, has prayed to file an additional affidavit to enclose certain document mentioned in the appeal memo.
My lord.
List after 2 weeks
Well,
Additional documents in IA.
in appeal memo.
IA, madam.
Yes, he will bring it through through an additional affidavit.
yes.
In IA.
In IA?
And annex,
Or appeal
yes.
IA?
In the memo, we have enclosed, but it ought to have been in the IA.
Okay. Which have been enclosed in the appeal memo have not been enclosed in the IA. An
Which
additional affidavit may be filed.
Yes,
With copy to.
Yes, sure. Copy
You
to-
get the copies?
Yes, madam. And we will file petition again.
Yes.
Objection. Again.
Lordship, can you see the office note dated? 29/8/2025, office note.
29?
29/8/2025. It has been indicated that the affidavit, to the extent that we have taken steps through paper publication, has not been filed. But then it has been filed today.
Okay.
So it may come up after 2 weeks, my lord.
Learned Senior Counsel, Mr. S. Dr. is present. Learned Counsel, Mr.
K. Jain.
K. Jain is present.
Lord, let it come after vacation. In the meantime, my lord-
Better after Puja vacation.
Puja
Yes,
vacation.
so many cases have been fixed in between.
Acha.
29 has 29. didn't it?
Lordship, on
But
the-
another thing, your lordship will see in item 28, second appeal has been wrongly tagged. Is in fact our case is
99 of 23, but it has been,
RSA 99 of 2023, but then some other file has been tagged.
but on last occasion in the order, it has been reflected as 99/22.
There is a mistake.
There is a mistake.
RSA 99, 2022. But
It
your
has been
case is-
disordered, but our case is that RSA 99 of 23, so it should be tagged with RSA 99 of 23.
We will talk privately to these people.
It's all right, Melody. Otherwise also,
They are like that.
It is not required to be tagged also. These are two different proceedings. Anyway, your lordship will see to that.
We'll talk. Even morning also I found some anomalies.
Much obliged.
Obliged.
May it please your lordship. Yes, this revision petition is against rejection of my amendment petition. And the service report on the opposite parties has come, my lord. The opposite party number 1-1 and 1-2 has appeared.
Yes, ma'am.
And 1-3, 1-4 and 1-5 are the family members, all are family brothers and sisters. My lord, your lordship may accept the notice of respondent, opposite party number 1. And my lord, other respondents 2, 3, 4, my lord, their pro forma, their name may be struck off. And
Maybe struck off.
Struck off.
What about your brothers and sisters? You are for 1A and 1B.
I am appearing on behalf of AZ Ahmed, my lord, engaged counsel.
Note, office note dated 22/8/2025. Okay. Learned counsel, Mr. KK is present for the petitioner. Learned counsel, Mr.
A Khalek on
A
behalf
Khan.
A Khalek on behalf of AZ Ahmed.
A Khalek on behalf of Mr. AZ Ahmed is present for AZ Ahmed is present for respondent number 1 and 2.
And 1-1 and 1-2.
1.1, 1.2.
1.1 and 1.2. Learned government advocate, Mr.
Here, Gogoi lordship, I am for respondent number 3.
is present on behalf of respondent number 3.
Lordship.
Full stop. It is submitted that the respondent number 1.3,
1-3, 1-4 and 1-5.
1.3, 1.4 and 1.5 are members of the same family. But
I don't know.
he doesn't want to represent.
This is he doesn't know one. Brothers and sisters, my lord, sisters.
Well, I am no aware of this case.
I think they stay in different households, maybe reside in different households.
Otherwise, you must be aware of Supreme Court decision. If one legal heir is in the is represented, then other.
The notice, the office note dated 22/8/2025 reflects that processes to 1.3, 1.4 and 1.5 could not be served. It is also submitted on behalf of the applicants that the names of the pro forma respondents may be struck off.
Yes.
Appellants or petitioners. For pro forma respondents 2 and 3.
2 and 4.
2 and 4.
My learned friend is there.
No.
Government.
Okay. 2 and 4 may be struck off. Push up the names of pro forma respondents number 2 and 4. 4 may be struck off at the petitioner's own risk. So we will wait for a service or we will continue.
Well, my lord may fix up for may accept the service report and will fix it for admission hearing. Otherwise, my lord, unnecessarily it will be delayed. Same family of brothers and sisters, my lord, on the same
It
side.
is submitted on behalf of the petitioner that the respondents number 1, 3, 1, 4 and 1, 5 are brothers and sisters and of our siblings of respondent number 1.1 and 1.2 and they are the legal heirs of the deceased respondent.
This is
What is
Sadekur
this?
Rahman. Sadekur Rahman.
This is respondent Sadikur Rahman and thereby their appearance is not necessary. Okay, this matter in the admission column.
My lord.
Okay.
Obliged, madam.
Obliged.
It's not required, not required.
Item 30. So as per office note in the main appeal, notices has been served upon the respondent and he is appearing for the respondent number 1. Other are not appearing.
Okay.
In the IA, injunction application due to or inadvertent mistake, we have not taken the steps in the IA.
Okay.
So we may be allowed to take step upon the 2 and 3 I'll serve the copy for one.
Okay. আর এফ টু লিখি দিয়া learned counsel Mr.
Yes, take.
S. Dekan.
Yes.
S. Dekan is present for the appellant. Learned counsel Mr. A.K. Gupta is present for respondent number 1. Office note dated 2/7/2025 indicates that two seven like where it is indicated that
Yeah.
indicates that only one respondent,
Three respondents. One has appeared.
but it is given in
The
singular form, respondent.
Yes, difficult is there.
Huh?
But the sense that we have taken both the register as well as usual.
It is not stated, my lord, whether it is served 2, 3 and not this.
What is the name of respondent number 2 and 3?
2 is
Two and three is the advocate.
Mr. Naresh Prasad and 3 is my lord Dumduma Town Committee. And no report or nothing is there in the file, my lord, I have checked.
No report, no?
No report.
Nothing is there, man.
So we'll take fresh step upon the 2 and 3 laws.
Okay.
In appeal also. It
Okay.
will be better law.
Okay. I had to লিখি দিবা তেনেকে appellant to take fresh steps to issue notice to respondent number 2 and 3 returnable within 4 weeks.
And method fixed on 15th of October also.
Okay, returnable on 15th of October. List
Okay.
accordingly.
Okay.
Item 31.
My lord, in this case, 2 and 3 has refused to accept the notice.
Oh,
And
that case, yes, yes.
yes, and now so far 1 is concerned, his sister also refused to accept the notice.
Yes.
So I think notice may be presumed as served because they are brothers and sisters and live in the same family. Any adult member who received the notice should be treated as served.
That already has, I have stated, I think. Lavadima course order. Or office note.
It is office note dated 21/5/25 and thereafter 6/9/24. 6/9/24 may be seen.
Six nine.
24. I'm sorry, 25. It will
We have latest order.
6/9/25.
Six nine 25. Today's 1/9/25.
But then 24 will be then. 24.
What about 3/4/2025 and 29/4/2025?
Thereafter, on 9/5/25, court did not sit. And then it is fixed on 27/8/25 for Lajim, I think. Lajim may see the 6/9/24 order.
Six nine 2024.
Yes.
Kawajima court has not formed any opinion.
Order 5 rule line is very much clear. So opinion of Lajima court may not be necessary because that is evident that the same family, other family members refused and 2 has directly refused to accept the notice, and one notice was served for brother and sister refused to accept the notice. So same family members, an adult person. So I think so far the matter of service of notice is concerned, that will be presumed as served and matter may be fixed for hearing.
But you see, this order was passed by Lazima Court on 34/2025. 5/5/2025, another bench of this court did not pass any order. It was observed that service not being complete list this matter on 21st May 2025. And the learned counsel appearing on behalf of the appellants shall apprise this court as to whether the service can be deemed to have been completed upon the respondents in view of the provisions of Order 5 CPC.
Yes.
Order 5 Rule 95.
Right.
And you will have to go to that High Court rules.
High Court rules.
Then again, that same bench did not pass any order on deemed service. The registry shall list this matter again on 9 June 2000. So today, why shall I pass any order? 3 dates that court did not pass any order. And then it was asked for the learned counsel to satisfy the court. That
Yes,
whether,
you see, yes, I am satisfied.
no, I know, you are satisfied. I am also satisfied. But then we will have to go to the High Court rules because in the proviso, that rules
High
are
Court
mentioned.
rules.
I'll give you some time, 2 weeks. 2 weeks.
Time may be given, but High Court rule cannot supersede the CPC because
No,
CPC is acted
no,
by Parliament.
No, cannot supersede, but
Ru-
provided that in the
Provision
proviso.
Act cannot be superseded by rules.
That is there, then why the other court did not pass any order?
Then what?
3 days.
3 days.
It was left for you to convince, and when you have not convinced, then it was fixed for another date.
Of course.
Along with the High Court rules.
High Court-
Because the proviso, according to the proviso Order 5, Rule 95,
Yes.
provided that the High Court rules are taken into consideration. So it is not relating to superseding the act or the rules. It is relating to taking the rules
I
into
am
consideration.
convinced that,
I
but
don't know the exact rules. I'll have to go through it, and then I can take the pains, but I'll need some time. Otherwise, you can
actually,
you can help me.
I'll satisfy you.
Yes.
But both are similar, not.
Today I do not have so much time actually. Today I have a lot of orders to pass also.
No, I have also
Chamber
got High
also.
Court rules today.
Hmm.
But in another court, it was in court number 4. If your lordship desires, I will show.
Today?
If your lordship desires, then I will show.
Yes.
After some
Later.
time.
Yes.
My lord, service on respondent numbers 3 and 5 completed by Dusty both personally. 2 and 4, their close relatives have refused. They were not at home. Close relatives have refused. So it may be deemed to be served. 1 and 6 already represented.
No. How can close relatives have? It must be brothers or sisters or
Yes, mother.
brother-in-law or son-in-law, mother-in-law.
Mother.
This is what I have been discussing with learned counsel. I have been discussing now.
The mother refused.
This is what I am discussing. Had it been father, then maybe.
Mother was not alive.
Maybe brother-in-law.
Brother also refused.
My lord, I am the brother. Here, we do not have any contact with them. So, we did not receive the copies. They stay outside of the Assam. They stay outside of, one stay outside of Assam and one is in Dibrugarh. And we don't know the address and.
High Court rules
And my lord.
of service of processes. You come with the High Court rules.
Yes.
I'll pass an order. I do not have the rules with me. And even if I have, I don't have time actually.
And my lord, the office note
Hmm.
of 28 August, it says 2, 3 and 4 refused.
Hmm.
It is there, my lord.
Directly?
Yes.
Then I'll pass an order.
It
for
is there,
deemed
it is there.
service.
Office note dated 28th of August.
The close relative, I
No,
won't
no,
pass an
2,
order
3,
for
4,
deemed
they have
service.
refused. 28th of August, my lord.
2, 3 and 4.
2, 3, 4, they have refused. 5 already completed through dusty mode.
Learned Counsel, Mr.
Mr. A Khan on behalf of F Khan.
A. Khan is present on behalf of Learned Counsel, Mr. F. Khan, for the petitioner. Learned Counsel, Mr.
S. Afridi.
Huh?
S. Afridi.
S. Afridi is present for respondent number
Respondent
1 and 6.
1 and 6.
1 and
6.
sure.
Yes.
You are having some doubts.
1 6 1 6.
Noran Kumar and
Kumar.
Lankeshwar Kumar. Lankeshwar Kumar.
No. Is the petition Kumud Kumar? I'm for the respondent.
Oh, Kumud Kumar, yes.
Yes.
Kumud Kumar and Noran Kumar, 1
Yes.
and 6. Noran Kumar,
Noran
1
Kumar.
and 6. Office note dated 28/8/2025 indicates that respondent number 2 has refused to accept notice which have been returned with the remarks as refused and returned to sender. Refused or returned to sender within inverted commas. Notice is hereby deemed to be served on respondent number 2. Further, the office note also indicates that notices have been served to respondent number 5 and 6. Only 3 and 4 are left,
3 and 4 also refused, my lord.
but by somebody else.
No, in the office note, it is 3 and 4.
No. No. You see, in this regard, mention may be made that here that unserved notices have been returned for respondent number 2, 3 and 4 with comments refused. Respondent number 2 only.
2 is refused.
And refuse return to sender. Okay, 3 and 4 also. It quotes 3 and 4. Uh, 2, 3 or 4 quote also, no? Refuse.
Like mark for us a second.
What's the service? Refuse, no? Oh, 2, 3 and 4 deemed to be served. Yes.
Deemed to be served.
We'll call for the trial court records.
My lord.
Notice is hereby deemed to be served. Call for trial court records. Scan copies of the trial court records.
I have a submission to make. The execution process in which the application was filed, it has been completed till date. So now
no point
of this.
to carry on with the petition.
Yes.
But still, my lord.
And the petition should have been filed as an appeal, since it's it contains a decree. But they filed a revision
No
petition.
stay order here.
No, my lord.
No.
Because the parties were not represented, so stay order was not passed. And regarding the appeal, my lord.
Do you want to proceed?
Yes, my lord.
Execution process is complete.
Because, my lord, I have no remedy available. Because if I file a petition, the order 21 rule 99,
yes,
again constructive res judicata comes in.
He also requires a remedy. So records to
Scan copy may be called for, my lord.
there is no order for calling records. No order was passed to call for record.
No, my lord. No.
You need the records.
It will be required, my lord.
Call for the scan copies of the trial court records. list after puja vacation
After puja vacation, my lord.
or in its usual course? Execution is complete in its
Yes.
usual course. List in its usual course.
Obliged, my lord.
Okay?
Yes, my
Usual course,
After puja vacation will be better, my lord.
list after puja vacation degree.
Obliged, my lord. Obliged.
Oh, more order pass কৰি থোৱা আছিলে। কোনে লিষ্ট order pass কৰিছিলে? সেইকাৰণে। এতিয়া একো দিবলৈ নাই নেকি order? এইটো দিয়া আছেতো, order দিছেতো। চাবলৈ দিছো তেনেকে।
My lord, I am appearing for the sole respondent, my lord. Here the suit has become infractious, my lord. Suit has become infractious, my lord, and in fact, we have filed an withdrawal application seeking to withdraw the suit without any liberty, and the suit is fixed tomorrow. So may I pray that my lord may not pass any order today. It may be listed after a week or so that we produce the order.
Yes. Learned counsel, Mr.
DJ Soika, my lord.
DJ Soke has prayed for adjournment. List the matter when?
After a week, my lord, because.
After 1 week.
Obliged, my lord.
May I please, Your Lordship? In this, we have taken justice service, Lordship. We have filed an affidavit also, but it's not on the record. We have filed it on 28th of August.
No, that new justice service is not on record.
Not on record.
Okay.
That's correct.
Learned counsel, Mr.
A. Ahmed.
A.
A. Ahmed.
A. Ahmed is present on behalf of the petitioner. Full stop. Service of notice to respondent number.
Sole respondent.
To the respondent is awaited. List the matter after 2 weeks.
Nice.
May it please, Your Lordship. My lord, the present review petition has been filed, my lord. My lord, in the impugned judgment, your lordship was pleased to allow 50% of the claim amount, my lord. However, your lordship has not granted pendant light interest, my lord, on my claim. Pendant light interest from the date of the filing of the original application was not given, my lord. Thus, the present review petition stands to that, my lord. My lord, Honorable Guwahati High Court in various occasions, co-equal benches have held that if the claim has been allowed, then it is mandatory to give pendant light interest from the date of the filing of the original application, my lord. And
you issue notice?
My lord, there was another thing, my lord, there was interpretation of section 106 was not considered, my lord. Under section 106 of the Railways Act 1989, my lord, the railways are obligated to investigate the matter. And
Your petition was allowed.
my lord, my petition was partly allowed. My claim, only 50% of my claim amount was allowed on account of there being a contributory negligence in the matter, my lord. However, my lord.
No, you'll have to issue notice.
My lord, my lord.
Yes. Learned Counsel, Mr.
D. Rathi.
D. Rathi is present for the petitioner. Full stop. Petitioner to take steps to issue notice to the respondents. Railways or Union?
Railways. Union of India, represented by the General Manager.
One respondent.
My,
Respondents returnable within 4 weeks.
my lord. Much okay.
Item 37.
May I please, your lordship? Your lordship, this MSc appeal has been disposed of before the learned Lok Adalat dated. Your lordship. 9/12/23. This MSc appeal has been disposed of. And in that Lok Adalat order, a sum of ₹5 lakh was awarded in favor of the claimant number 4, that is the mother of the deceased. But after passing of this award and prior to withdrawal of that amount, the mother of the deceased expired. I have annexed the death certificate also.
Okay.
So my prayer is that other applicants are there, other legal heirs are there. So your lordship may allow the wife of the deceased, who happens to be the applicant number 1 here, to withdraw that 5 lakh. That 5 lakh has been retained by the registry.
Okay. Has
Passed
away.
away after passing of this order,
Okay.
but prior to withdrawal. I have annexed, it is page number 10 in my application, death certificate. The order was passed in December 2023 and she died in January 24. My applicant number's one's husband died.
These are the children and wife.
Yes, children and wife.
Now she is not survived by any other legal heirs.
Your
Mother?
lordship?
Mother?
No, they are the presently applicants are the only legal heirs.
But there has to be class 1 legal heirs. When the mother has passed away, her amount has to go to class 1 legal heirs, not any applicant or claimant or.
Your lordship, then I have to take instruction. Your lordship may fix another.
Yes. I'll. It must go to class 1 legal heirs. I to लिखी दिया. List this matter after 2 weeks.
Yes. Oblige.
Item 38.
Made to zero. Well, this is for substitution of legal heirs of respondent number 16. Well, there are 3 petitions, my lord. IA has been listed. One for condonation, one for setting aside abatement, and one is for substitution. My lord, the service report has
We'll
come.
start with the condonation first.
My lord.
If there is no objection in condonation, then other petitions will be easily allowed.
16, Lord.
Okay. What is your condonation petition? Petition number?
Petition number, my lord, 1086.
Yes, Lord. This one.
You have any objection?
Today I have filed a ballot number today on the lordship. I have been engaged today and morning.
Okay, you have objection.
No, he has no objection. 16, he is.
Respondent number 16, yes.
He is the legal heirs.
Oh,
Yes, lordship.
I didn't hear
On the
you.
death of my father, that is Hirok Jyoti.
Substitution হবে না?
Yes.
তুমি
Legal heir is
substitution হবে।
Himani Chakraborty. Himani Chakraborty is the legal heir and the deceased respondent 16
How many
is
days of delay?
delay, my lord, long delay, 1075 days.
You have any
No,
objection?
no. They are the pro forma.
Pro forma respondents. Third learned counsel, Mr.
KK Day.
KK Day, A to 1086 for the applicant who has filed this application with prayer for condonation of delay on the date of respondent number 16.
My lord.
In RSA number, arrayed in RSA number 249/2017. It is submitted that. Where is your ground?
The ground is, my lord, my original advocate died, my lord, paragraph 3, my lord, at page 7.
Delay of 1075 days, huh?
My lord.
It is submitted that the earlier engaged counsel of the applicant died on.
That when the date is not. He died when after that, when I had to, I had no knowledge, my lord, thereafter I had to engage when separate, another advocate, my lord. I must say HRA Choudhury.
Where is your ground in which paragraph?
Ground in paragraph 3, my lord. Well, it is not happily drafted, my lord, by some, drafted by some other advocate.
Died on 20/12/2021.
2012/2021. Thereafter, without the knowledge of the applicants, this case was proceeding. Full stop. Third, Mr. S.K. Ghosh, no? That counsel for respondent number?
Respondent number 2, 3, 5, 6, 12, 17, 18, 19, 20 and 21.
Learned counsel, Mr. M. Hussain for respondent number?
I only the legal year certificate.
Oh, no, nalage to go. Nalage. He is already not, he is not present now. In IA, he is not present.
Present. Present.
Okay.
He is present.
Respond number for legal heirs for respond number 16.
Yes.
Learned counsel, Mr. M. Hussain is present.
M.N. Rahman.
Huh?
M.N. Rahman.
M.N. Roman is present for legal heirs of respondent number 16 and learned counsel, Mr.
I am for respondent number 1. In RSA. In IA, only he is the part.
It appears that there was no malafide on the part of the petitioner. The learned counsel for the respondents has no objection. The petitioner has shown sufficient grounds. Full stop. It is inevitable that when the learned counsel, engaged counsel expires, the clients will not be aware of the pendency of the proceeding. Full stop. When the applicants learned about the death of the engaged counsel, then the applicants have learned about their plight, PLIGHT, full stop. Considering all aspects, delay is hereby condoned. Delay to file what?
Delay to file substitution petition.
Delay to file substitution, delay to file a petition for substitution of legal heirs is hereby condoned. And for setting aside the abatement.
Abatement, it is 1088.
Abatement is condoned.
108.
My lord, in the main case, my lord, in IA.
Okay, RSA to লিখাচোন learned counsel Mr. সকলোৰ নামে লিখি দিবা আৰু learned counsel Mr. is present for respondent number 1. M. Hussain is present for respondent number 1. The amended cost title to be filed in this case.
My lord, there was an earlier order, my lord, in IA 469/2025. IA 469 disposal.
For what?
It is fixed for hearing. Early hearing petition I have filed, that was allowed.
When do you want this to be heard?
Lordship's convenience, my lord.
469 to beleke likhi diba, huh?
Date may be fixed, my lord.
IA stands, it was closed.
It was closed. There was an order for
Okay, okay, early hearing of the, okay,
Yes.
okay. RSA.
RS.
Okay, when do you want?
As per his wish, madam.
After vacation?
No, before vacation, because there is an,
Before vacation?
my money has been,
Before vacation, not possible.
16 October.
Huh? Or earlier, 16 October.
Earlier, 16 October.
Actually, all the RSS are being listed hurriedly. I don't know why suddenly 2 benches have been set up and RSS are listed. I don't know, maybe many RSS are pending.
From 2008, 9, 10, RSA is still pending.
That is why, maybe. This is the reason. Suddenly 2 benches are.
And in the hearing list also, all the 2010 has been listed.
Yes.
In part 2 hearing list.
Yes, I know. I have heard about it. That's why they have set up 2-3 benches.
Well, RSS subject matter is small, but hearing is long.
And then the case execution is also always pending.
2010.
Huh?
Item 40.
Much.
IA 2673 25.
2673, yes.
Yes. Decision filed by the applicant for substitution. They are the legal heirs of respondent number 20. Girish Bhattacharya. So that may be allowed because.
Can be allowed legally as substitution.
Legal
of
heirs,
the-
wife and daughters.
Third learned counsel, Mr.
S. Afridi.
S. Afridi for the applicant, learned counsel, Miss.
Pranjalika Patwari.
P.
No, no,
Patwari
I'm
for
the
the.
appellant. Pranjalika Patwari is the applicant. I am the appellant.
Okay, ulta ke likhi diya. Miss P. Patwari for the applicant and learned counsel, Mr.
I'm A. Bhuya. I'm appearing for respondent 1, 9, 10, 11, 12, 13, and 14.
You are the applicant, no? First of applicant likhi ba, respondent hote ho.
Respondent number 20.
Applicant, stroke
Applicant
respondent number 20.
Yes.
Comma learned counsel, Mr.
A. Bhuya.
A. Bhuya for respondent number
1, 9, 10, 11, 12, 13, and 14.
and learned counsel, Miss.
A. Sharma for 2 to 8 and 15 to 18 and 21.
What's that? 2 to 8,
2 to 8, 15 to 18,
comma 15 to 20 and
21.
and
15 to
21.
18. 19.
15 to 20, not 15 to 20, 15 and 20. 15 and
18.
15 to 18, okay. Learned counsel, Mr. S. Apriti is present for the opposite parties.
Yes, opposite party.
Opposite parties stroke applicant. Full stop. This petition is filed on behalf of the applicant. Under Order 22, Rule 3, read with Section 151 of the CPC for substitution of the legal heirs of late Girish Bhattacharya, heard both sides. Considering all aspects, the legal heirs of late Girish Bhattacharya, namely, where have they been named?
Respondent number 20. In RSA, respondent number 20.
No, the legal
Page
heirs.
number 13.
Page number
13.
13. Oh, page number 13 or something. Are to be substituted and read as respondents in the connected RSA number
5.
5 of 24.
5 of 24.
5 of 2024. You filed this within the period of limitation?
Yes.
Yes.
Yes. In terms of the above observation, this application stands disposed of and amended cost title to be filed in the connected RSA number 5 of 2024.
Your Lordship, I have also filed an IA for 2733 for correction of address. For correction of address.
Third learned
As
counsel,
per order.
as already for the appellant.
Yes.
Who has submitted this application for correction of
Addresses of defendant number 22 to
address or respondent number
22 to 22 5.
22
2 within
Two.
bracket 2
and
22-5.
22-5. As
Well, by the order dated 39-24, I was correct address was to be endorsed.
where is the correct address? In which
Yes,
page?
In page number 9,
Page number 9 or 7. As
para 2 of the petition.
para 2,
Yes.
page
Uh,
number 9
next
of the
page.
petition.
Yes, next page.
Para 2, page number 11. Here I have page number 11.
Okay, so
Near Royal Palace, Simonto Sankar Nagar, Pathor.
yes, yes, that.
Blue tick digits, paragraph 2 ase, huh? This is the correct address, no? Pathakori, magazine number 76, Namghar Pot.
Yes. This.
Okay. Uday Bihar District, Kamrup M.
Yes.
Pin 781171.
Yes.
It will more blue tick digits, page 11. Heard the learned counsel, hey, agor jikin likhi disila, correspondence. Prayer is allowed to correct the address as prayed to correct the address accordingly. In terms of the our observation, this petition stands with post of RSA to Liquidia to be listed as per usual course. RSA to be listed as per usual course.
Okay.
Item 41.
It says come for the first time, Lordships. IA is for condoning the delay of 119 days, Lordships.
How many days?
119, 119.
Other side is not present.
For the first time, Lordship, notice is to be.
Issue notice to the respondents, returnable within 4 weeks, list accordingly. Item 42.
Testimony appeal, madam. Two petitions are there. One is application for leave and the other is condemnation. In both the cases, a notice has to be.
Issue notice to the respondents, returnable within 4 weeks.
Yes.
IA or RSA duita de, huh?
No, IA and two IA.
Oh, two IA, RSA
One-
no hobo.
One leave and one.
Testamentary appeal. Duta IA notices di dibo.
Both the,
Appeal to no de.
both the IAs.
Huh? Eunukor IA kita. No, this one
Notice will
notice,
go.
notice. Returnable within 4 weeks.
May I please your Lordship, Lordship, item number 40 in IA 2733 notice, I may be allowed to take steps upon the respondent. Steps are not taken.
2733 লিখি দিয়াচোন মেনু কৈ দিয়াচোন notice issue কৰিবলৈ
In that matter,
yes, you have to take notice to the newly implemented, yes. Issue notice to the substitute legal heirs.
The other side has come,
Present.
we'll give them the copies.
Yes.
And the thing is, the correction of address, in the correction of address, we have corrected the address now. So I may be allowed to take steps upon the correct address.
Yes. Tatu di dibo koi diba. Corrected address je. Notice to be issued in the correct address of the respondents will likhi dile hoye jabo.
Okay.
Item number 43.
No, please, your Lordship. The delay continuation, Lordship. Delay continuation was,
Matrimonial appeal, no?
Lordship,
How many days kile?
2548 days.
Issue notice to the respondents returnable within 4 weeks.
Alright.
Item 44.
Well, my lord, 10 days delay. 10 days delay.
No, you have to issue notice.
Yes.
10 days delay also. Yeah. Issue notice to the respondents returnable within 4 weeks. It will be condoned, but you will have to issue notice. Right. Timely item 31.
My lord, I have checked
Yes.
this Guwahati High Court rule.
Yes.
Actually, my lord,
there is nothing elaborately written, but one thing has been clearly stated that Guwahati High Court rules for the service of notice.
What?
Chapter? It is in the original Guwahati High Court rules. Here is nothing.
The new one, rule number? Chapter which one?
Chapter 25.
Chapter 25?
Yes. Here, my lord, it is said that Guwahati High Court rules for the service of notice are governed by the Indian Civil Court, Civil Procedure Court.
Okay.
So that is only there. So CPC will guide.
Okay.
In that view, my lord, notice may presume as served.
Chapter 25, no?
Yes.
No, we have the, you see, we have the amended rules, no? Now we'll work.
Amended rules also is maybe there.
Now we'll have to work according to the amended rules. There are 9 again. Change.
I also do not find.
Process fees.
Yes,
Paper book.
other things are there. Criminal matters, company matters, CPC. I do not find any chapter of CPC. But only civil office, it is written that the notice shall be guided by CPC.
Can't you think? Pona rule to take it and says it. Notun rule to nai po. Notun rule to pona mila nai. Civil appeals rules to preparation of record. Chapter 15, Appendix 1. This is marked here.
Here is nothing. Only says that it will be guided by Civil Procedure Court. More than I have not found anything.
Number 2.
CPC, right? CPC, what that is question. Here, one thing, my lord, this order 5,
Rule 5.
Rule 9, Order 5, Rule 9, it is said that in case of service of summons by plaintiff or a courier where a return is filed, that the defendant has refused notice.
That I know. It is deemed to be served, I know, but that they have mentioned about serving it on a woman who has refused to accept. So it cannot be accepted as deemed to be served. Because serving on a woman.
Woman or man, there is some, but adult is the word, adult is there.
CPC, I think it has to be served on a male member, I think.
Our full bench decision in Muslim Mondral's case, it is said any adult member of the female. Full bench judgment.
But it is not relating to CPC.
But that was in respect of foreigners matters. Okay, well, I think let
2 weeks time. 1 week time. কোনটো আছিলে? List this matter after 1 week. হৈ গ'ল নেকি?